Hello, everyone. Hello, Sky Troop. Howdy, all. Sarah put on quite a show of facial expressions today and was busy scribbling notes through much of it, too. I'll bet she's going to have I bet she's going to have trouble controlling herself during trial. I think so, also. I myself have not watched this. I'm waiting. Hey, Jane, brought to you from Canada. Hello, Margaret. Hello from Wisconsin. Hey, Crimes. Hi again. Hello, my friend. I had to say hello to everyone, so hello. Hello, Hugh. How's it going, Hugh? How are you feeling today? Oh, that's okay. I figured as much. It's Sarah. I hope everything's going okay, Hugh. Hello, Miss Sky. All right, we're going to jump right into this. Doing better today, thanks all. Glad to hear, Hugh. Hey, let's just jump right in. There you go. Hello, Bee Rabbits. How are you, Bee? It's been a busy day. Oh, look at how pretty she looks. Be right back, guys. I got to turn my other TV off. I can hear it in here. Be right back. Such a beauty. Drunks the bear. Hey, Broken. Welcome back. Hello, Shiraz. Welcome. That haircut above her back hairline is something I will never understand. I get it. Hugh says Sarah probably can't go near a suitcase without thinking what she probably, if she could, she'd probably go shopping for better suitcases. Jane says Sarah made a bunch of faces, but the award for best sound effect goes to the second, third chair lawyer who sneezed a lot in front of the judge and sounds like a squeaky toy. Awesome. Hello, Bumble. Welcome back to a different live. It's been a busy day. Oh, Moses. I think she thinks herself as a lawyer, not a criminal. I hate this light. I'm going to try a different light. 1 second. That light's too harsh on my eyes. That's better. Broken says the second chair is not even a lawyer. I think just wait and see his arguments today. Yeah, I have, guys, full disclosure, I have not watched this at all. I thought, you know what? I'm going to react to it as if I was watching it for the first time. Hugh says Sarah claims to excel at everything except when packing a suitcase. Jane says the woman who delivered the clothes were wearing the same suits. Things like that make you go, I know. I really thought the Barker's Beauties were going to be second and third chair, but obviously not. I'm not sure what you're saying, Miss Guy. What is the over under that everyone gets COVID from the ground zero jury panelists? Oh, another delay. I just want this case over with. It's been forever. What are you taking my papers for? I wonder why Barker's Beauties were there for that one hearing, but not. I have. Who here has seen Chicago the Play musical? I have. I guess I don't have to wait. It's not live. I can get us to when they start. What am I doing? Her first suit looked disheveled and sloppy, but her blouse matched the putrid green chairs I kept thinking of Oliver the musical. She thinks she's Renee Zellweger character. Oh, she does. I think you nailed that one, Shrez. Considered yourself at home, considered yourself part of the furniture. Welcome back, Leah, to the new live. There we go.
William J. for the state.
James Owens on behalf of Sarah Boone.
Tony Henderson on behalf of Sarah Boone.
Ma'am, good morning. Can you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
All right, Ms. Boone is seated at counsel's table wearing a gray suit and a white blouse. She is out of custody and unshackled. Mr. Beck, you arrived late, sir. Can I get your appearance for the record, please? All right, thank you. All right, we're here on a litany of different matters, multiple motions in limine. The state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force filed October 6. Defendant's response to state's motion in limine to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testified filed October 15th, and then the defendant's amended response to same also filed October 15th. The defendant's motion in limine filed October 6th. The state's response to same filed October 6th. State's motion, objection and motion in limine to exclude decedent's medical records filed October 14th, and then the parties' objections with regard to specific exhibits that may be sought to be entered at trial. The court has reviewed everything and reviewed all of your case law, and we're ready to proceed. I believe we should probably proceed first on the battered spouse motions first. So state, you may begin. And I also have reviewed as well the excerpts of the deposition of both Dr. Warner and Dr. Harper as identified in the state's motion.
Shiraz says, so she does this to herself. It's so odd that she can't see it. She's so freaking delusional. It's unreal. Jane says, you got it, Shiraz. Now she matches the manila folder. So clever. I still was hoping she'd come in with barrettes in her hair or something. Can we get her suitcase barrettes? Send it so she can wear them for trial. Hello, Irene. Welcome back.
Your Honor, for the record, I'm having Madam Clerk mark A, B, and C for identification purposes for this hearing. A is like the defendant's session body worn camera, Deputy Sheriff Kayla Rodriguez on February 24th of 2020, as well as the interview that she provided to Detectives Copsell and Lowen on February 24th, 2020, and February 25th of 2020. It is an identical exhibit as to what was provided to the court for review in chambers as a courtesy before the motion to suppress statements, as well as what is entered into evidence for that motion to suppress statements hearing that was held. State would move A for identification purposes, in as one for the purposes of this hearing.
Responses to what was pre-marked as A.
No objection.
All right, what was pre-marked as states A will be
I
received
love
without
you.
objection as states 1.
B for identification for purposes of this hearing is the deposition of Dr. Harper. We would move that into evidence as states 2 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as B will be received without objection as states 2.
C for identification for purposes of this hearing is the deposition of Dr. Werner. State would move that into evidence as states 3 for the purposes of this hearing.
Any objection? All right, what was pre-marked as states C will be received without objection as states 3.
So Your Honor is familiar with all those exhibits and has been able to review them prior to the hearing, so I will just proceed to the legal argument.
You may proceed.
Your Honor, this is a motion in limine. we are asking for a pretrial ruling based on the proffered statements that the defendant has made, which should, in good faith and reliance, the state should be able to assume that that will be her testimony at trial, given that her latest version of events was just given to our expert last week. So we are asking for a pretrial ruling on if that is the evidence that comes in at trial, will she get a self-defense instruction? Will she be able to then open the door to all the things that come with self-defense, such as reputation evidence of the victim for being violent, which she may or may not be aware of, that's not required under the law, or prior instances of violence between she and the victim, or the victim and anybody that she is aware of, because that goes to the reasonableness of her perception of an imminent threat of death or great bodily harm. We are not asking to not be allowed to talk about these things during voir dire. The defense cited numerous cases and spent some of their time in their response about the ability to voir dire. That was not the purpose of our motion. I don't think we mentioned voir dire. Because we understand that the defendant can, like any other witness, change her story again. So we understand that we both, on both sides, we intend on spending a great deal of time on it as well for the state of Florida. We need to explore these issues during jury selection. But what we are asking from the court now preliminarily is, if that is what the defendant is going to say in trial, and I'm not asking the court to make any credibility determinations about one version or another. We're asking you to treat this just like a C4 motion or a motion for summary judgment in a civil case. If this is what she says, does this amount to what they are asking for legally? And it's the state's position under the case law that no, because under her statements that she gave to the experts, there was no overt act taken by the decedent on that day. There was no overt action. And that's what's required under the law to trigger her response of acting in self-defense. There was nothing creating an imminent fear of death or great bodily harm to her until she committed 2 forcible felonies and a non-forcible felony. What her testimony was is, we were having a good day. Now, what's different, and again, we're not asking you to make a credibility determination about what's different, but what is different than what you had heard at the motion to suppress is, we were having a good day, but I'm on edge every day because of past instances of violence, including an instance the night before. But we were having a good day. We're out on the porch. There's a dartboard out there. There's puzzles that we're doing. We're doing arts and crafts. We're doing everything to keep him preoccupied so he doesn't get sad or upset. Interjecting with some phone calls to his family, which she knows would potentially upset him, but that's her testimony. And then eventually it comes to a point in time where they're sitting on the couch and he reaches over to her and says, "Tag, you're it." And she apparently runs up to the shower to hide, and he apparently gets into the suitcase to hide, and it's not clear who's it. Eventually, she comes down out of the shower after she says she was getting cold up there and sees him in the suitcase and zips him up. And at the time that she zips the suitcase, what she describes as nearly entirely shut, but 2 fingertips could get out. Mind you, a 103-pound man, 2 fingertips. They're laughing. It's all fun and games still. There's still no overt act taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, of great bodily harm or death. And it's only when he begins to say, after she has zipped him up into the suitcase, again, she is saying that she did not have malintent at that time. When he starts to say, "I cannot breathe," now she describes to the doctors that she does have bad intent, and she wants him to feel what she has felt in the past. She gets angry, is her description. She shakes the suitcase, she beats it, it falls over, it flips over, he sticks his fingertips out, she hits him with a bat. So she's now the initial aggressor, and we'll discuss jury instructions as we get closer, but she's the initial aggressor, and she has now committed forcible felonies, aggravated assault, and aggravated battery, stating that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived, according to her, that
Sorry, guys. I need to figure out where he's getting this. Did she do a depo or something? Because I've never seen where she has said she hit him with a bat and stuff. Is this part of the new defense that they're putting out? Like, he's obviously reading it. Hi, Crimes. Sorry, guys. I was watching Lalani case with Grizzly from the state psychiatrist. Ooh, we need to get our hand on that. I wonder if that's obviously now it's open documents.
he would die or face great bodily harm. And she just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out. And she completely expects him to get out because her testimony is that he could get 2 fingertips out of the zipper. So, Your Honor, under the law, the state understands. We are deeply thoughtful about this request because of the risk of error. But this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is. And therefore, the jury.
She's trying to explain why she was defending herself from a guy trapped in a suitcase. In doing so, she had to explain that she hit him with a bat and knew he would retaliate if she let him out. Oh, I understand that, but I was like, so I want to try to find this write-up that the psychiatrist has. It obviously should be open documents now. Because that would be interesting to have and read. Definitely would be interesting. Sky says Crime and Coffee Crew. I think he says the name of the doctor at the beginning. If you want to check later, yeah, I'm definitely going to check. Because I was seeing the minute he said dartboard, I'm like, wait, she never said that in any of her interviews. So it would be interesting to see the whole write-up, because obviously he's going to be doing some summarizing of it. There's more new stuff you'll hear, Rochelle. Just wait. It's good. I guys, this is me first reacting to it because I said, you know what? I'm just going to wait and react with the Coffee Crew. It won't make any damn sense, but it'll be interesting. Yeah, it would definitely, because it's like you could almost pick her words apart. Go to her one interview where they were out having a cigarette on the balcony or deck or patio, whatever they call it. And now there's a dartboard out there. I'm like, okay. Irene, no spoilers from me, just sass and snark. It's Sarah Boone, right? It's Sarah. She's got herself solidly painted in a corner. She truly does. Like, she can't remember her lies at all. In the one interview, right? Everything was good. He was going through his DV courses. Everything was great. He even said to me, "Oh my God, Sarah, I'm so sorry I've done this to you." So everything's good. But now it wasn't good. And you started beating a man in a suitcase. No, I think she has to say she beat him with the bat from the suitcase because the evidence shows he was black and blue, had head trauma because she pushed the damn suitcase down the stairs. So she's got to just get that out of there somehow. This woman's a nut job.
Jury should not hear about any prior instances of violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that is self-defense that's recognized under the state of Florida's laws. So what we're asking for is a ruling that if, and this is a motion in limine, and a motion in limine is, hey, this is what's proffered to the court prior to trial. If this is what comes in at trial, this is the court's preliminary ruling, unless something changes. What we're asking for is a preliminary ruling that if that is what her testimony is, then we should not be allowing introduction of past instances of violence, reputation for violence.
Go ahead, sir.
For battered spouse syndrome evidence. And furthermore, what the case law supports is our request that clearly this evidence can only come from her. There was nobody else in the apartment or townhouse that night.
Irene says, I read the autopsy report last night. She beat the brakes off him. Yeah, it's disgusting. I was modding on a channel that covered this earlier, which means I missed at least 70% of it. Well, then we're in the same position, Shiraz. Jane says, oh, and if she was smoking, then she never gave George CPR either. OMG, yes, at Jane, I need some. It's overcast and 72 here. Warm cup sounds is so cold. And my office, this room, is the coldest room in my house. So I think probably tomorrow I'm going to be changing my spare bedroom up because this is the coldest room in the house.
So she should have to testify before any of those things come in. And her testimony should meet the requirements of an overt act before any of this testimony comes in. It should not be allowed to come in prior to her testimony. And under the case law that the state cited, it's not unfair. It's not forcing her to testify. She chose to raise battered spouse syndrome. The state completely understands we have the burden of disproving self-defense beyond a reasonable doubt. But what the case law says is we shouldn't have to combat this. We can't put the toothpaste back in the tube until she actually puts forth the self-defense that justifies all this. So that is our request. We're not making any requests about voir dire because we understand she can come in and testify differently yet again at trial. And that's a discussion we'll have to have as well about how that will occur. The state's position is that if she changes her testimony yet again, she should have to give a narrative testimony. No attorney should be allowed to participate in putting forth new testimony about the events of February 23rd. Thank you.
All right, thank you very much. Response?
Good morning, Judge.
Morning, sir.
I'm a little confused, but I want to make sure, so probably can save some time here.
You're a little confused, sir. Why? Because you're Sarah Boone's lawyer or representation? Why are you confused?
My understanding is what the state's saying at this time, that there's no objection to raising this in voir dire to see how the jury would react or their feelings about it. So that's not it. So what that leaves me is, I guess the state's trying to say there should be no mention of battered spouse or anything like that in opening statement.
That wasn't my takeaway either. My takeaway from the motion and the state's argument today is from a evidence perspective, concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances of conduct that are contemplated by self-defense until there's a factual basis for it. My understanding of the defense's Dr. Harper's deposition is that the basis of her opinion, and please correct me if I am wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Ms. Boone as to what transpired on the day and night in question. Is that accurate?
I need to confer.
Sure.
This guy just got on the job. Did Owens go out on the street and say, I need a second chair, and just pick any random person? That's what I'm thinking right now. Oh, gosh.
Judge, if I could have you repeat that question.
Sure. So my understanding, well, let me ask you, I'll have a more of an open-ended question. What is the basis factually of Dr. Harper's opinion? So if we were at trial right now for the purposes of this exercise, and you were going to call Dr. Harper to testify, what is the factual basis component under 90.702 in order to get her to testify? We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's just assume the state has no objection with regard to her credentials and that she is in fact an expert based on her knowledge, training, and experience in her field. What is step 1 under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that her opinion would be based on is her interaction over the course of time with our client, Ms. Boone. That's one. But Dr. Harper has also reviewed other evidence in this case that helps her form the basis of her opinion, and also her knowledge of battered spouse syndrome. That has to be taken into account because, quite frankly, Judge, people who suffer from certain things, they don't know. That's why you have to, like if you have to get an expert opinion as to someone's mental health situation. I mean, a person doesn't really know that they're suffering from a mental health problem. They have no idea in a lot of circumstances. What they do is they get evaluated by a doctor. The doctor has experience of what signs to look for in these things, and getting those signs with what they told and outside sources too. They are able to make a determination based on their training and experience. So,
but based on the Akendo case, which is cited by the state as to what battered spouse is it's an ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
yes, but this is the problem that I'm having here. Self-defense is a defense, it's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act by the victim which would have given rise to self-defense? Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case, but
What
that
is it?
has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely agree with you on that. And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing with the jury instruction right now. What I'm dealing with right now.
I agree, Deb. This lawyer's not very knowledgeable, and this is the first time me seeing him. In my opinion, defense team not very prepared. I agree 100%. And you know what? That'll be just used for an appeal. Guaranteed. Happy Rabbit, she's praying for a phoenix to rise from the ashes. Yeah. B Rabbit, yes, indeed.
Now is pretrial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
If you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work. Because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense, has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Ms. Boone or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited and the doctor answers. But that's not what this has to be based on. What it has to be based on is what does Ms. Boone, in this case, testifies to on the stand. And if any of that, excuse me, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't.
Darn it! Come on. Sure as his apples just got me. In Florida, if an appeal is filed and an effective counsel, the attorney is subject to investigation by the state bar. That's going to suck. Darn it, darn it, darn it. Well, it wouldn't be Rochelle if I didn't mute once. So I guess that's my catch, right? That's my thing. I kind of hope so, Irene, in a way, because the fact is then maybe it'll come out how he even got on this trial. Because I still think it's suspicious. I still do. She wanted a skirt and no shackles so she can do the bend and snap. Oh. Jane, I just pictured it. As I was reading, I just pictured it. Oh, Lord. Oh. So maybe that will open the door to that. And I guess I have to say this, guys, and I'm going to say it because it's freaking hilarious. Rochelle has been saying that Charlie was in Leon County, has not been transferred yet. All of this. There was no proof that he had left yet. I have been trolled about that, called a liar about that, and guess what happened today? Charlie was transferred from Leon County to a Florida prison. It's funny. It's funny. We missed the big guy's squeaky toy sneeze. Is that when the judge said, bless you? Because I can go back. This ain't live. Mute is messing around. Yeah. He also said, is this lawyer the respondent to Sarah? And she placed looking for an attorney. We don't know. And B Rabbit answers, Hugh could well be. He's very Craigslist-like. Yeah, I think he had help. I agree with something just isn't right with this lawyer. I agree, Hugh. Jane, I will do it for you. I will do it just for you. B Rabbit, yes, but Rochelle, you don't peddle in fiction. I said it once. I'm like, there's no transfer. There's no nothing. There's nothing. There's not even a new mugshot for the prison that he would be going to. There was just nothing. So I'm like, he's still in Leon County, guys. He does it at least twice here. Funny AF coming from this big guy. All right, I will go back. I will go back. Why not? We'll go back a few minutes. That way we won't miss it.
The doctor has experience of what signs to look for in these things, and getting those signs with what they told and outside sources too. They are able to make a determination based on their training and experience. So,
But based on the Akendo case, which is cited by the state as to what battered spouse is it's an ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
yes, but this is the problem that I'm having here. Self-defense is a defense. It's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act by the victim which would have given rise to self-defense? Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case, but that has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely agree with you on that. And the case law is clear that if there's a scintilla of evidence, I have to give that instruction. But we're not dealing with the jury instruction right now. What I'm dealing with right now is pretrial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
And if you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work. Because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense, has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Ms. Boone or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited and the doctor answers. But that's not what this has to be based on. What it has to be based on is what does Ms. Boone, in this case, testifies to on the stand. And if any of that, excuse me, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
Any other arguments, sir?
No other argument.
Thank you. Rebuttal.
I agree, Leah.
This is procedurally correct. Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there. But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? What happened next?
Sorry, guys.
And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I've cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog and that bad dog bites and that bad dog is bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay, and you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up. That triggers you to, I remember when the dog bit me in the past. you can't, that's not how this works. That's not how self-defense works with or without battered spouse syndrome. There has to be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking, unless they are saying that the testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know based on the court's ruling what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies and it's clear and convincing and it meets all the standards under.
Sorry, guys, not feeling so well today. Are we really getting opening arguments tomorrow? I don't know. I wonder if they finished the jury selection today. Top Cat says there has to be an imminent danger to you for self-defense. And I know I heard that they're saying that my phone's going off. I know that they're saying that she feels if she would have let him out, he would have came at her. Well, lady, you're admitting to beating him with a baseball bat while he's in a suitcase. Come on. No matter what gains the defense team may make, Sarah will blab her way to ruin all of it. Yep. Hugh says Sarah and George didn't have jobs, but have plenty of money for booze and cigarettes, all coming from her alimony payments from her first husband. Deb says, listen to what defense says the overact is. Will do. No jury selection, finishes tomorrow and maybe opens on Thursday. Thank you, Sky. No, they are still asking questions of jurors tomorrow, maybe by afternoon for openings. Okay. I think they're going to say that the imminent danger was his 2 fingers sticking out of the suitcase. They were being violent. They were just stiff and being so violent she knew what was coming. Unbelievable. One of those 2 fingers, this is pretend Sarah Boone, one of the 2 fingers was the middle finger, and he was making sure I saw it. And I knew what was going to happen. Yeah, where does the not intentional fit into it, right? That's what I was talking about. The first thing they were talking about from the doctor, like her previous statements. Which one's real? Which one's right now? Sarah, which one are you choosing? Because not intentional means she wasn't in fear. And there was a part where she was in the shower and she was cold. She said she didn't say she was having a shower. She said she was hiding in the shower. So come on, Sarah. You could make a board game out of this woman. Oh my God.
404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right. Thank you.
Dan.
Judge, could I respond?
Briefly.
Boone. Oh, Boone bingo. You know what? We should, I should try to come up with something and then email it to everybody. Different Boone bingo cards, because I love that, with different things Boone says. And then when she's on the stand, try to see if who can fill a card of different things that Boone could say. Oh gosh, that'd be brilliant. Boone bingo. Do we think she's going to be long on the stand? Like, is she going to be like Charlie on the stand? Almost 2 days? Deb, it does sound fun. Come up with different Boone sayings or whatever, and, you know, see if, do a full card for Boone while she's on the stand. I think that'd be brilliant.
Judge, it is not the responsibility of the defense to present their case at a pretrial hearing. However,
But the problem is in the state's art, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing jury selection and the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are Jorge Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
yes.
And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge, but I find myself in the position now to disclose what our view of the overt act is.
Okay.
That's what this is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Ms. Boone by the overt act. And the overt acts, I have to tell you, his hand is coming out of the suitcase. That means he's about to get out of the suitcase. Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence, because there's a picture provided of Mr. Torres's hand that shows a mark on that hand that it matches up with the bat. That's the overt act. It's like a gun, okay? You don't have to wait for them to pull the trigger. You don't. And it's based on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
Thank you, sir. All right, the court has had the opportunity to review the
Oh no, 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 no. Oh, she finally found lawyers that were as nutty as she is. She said his little fingers were popping out, not his. The overact is because, oh, come on. This is disgusting. Hear this lawyer speak. Top Cat says this has gone on long enough. Just toss the self-defense. Oh. Deb says, told you. Him trying to save himself PO'd Sarah, so she beat him and made sure he would never get it. Oh my God. Hey, Jane. Welcome. That was so brilliant, guys. I'm sorry. I have to go back. I have to go back. This. How ridiculous this case is. 2 fingers will be prosecuted. I can't even with this. Can you imagine the jury's face if these dummies argue this? Jurors, and I seriously thought you were joking. This guy's in. Oh. Cracker Jack lawyers. That's what my nickname is for type of these lawyers. Cracker Jack lawyers. They found a Cracker Jack box and it had a diploma in it. Oh. Your Honor, his fingers scared me and I was afraid for my life. I've never heard anything so bizarre in my life. I've never heard anything so bizarre.
testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge, but I find myself in the position now to disclose what our view of the overt act is.
Okay.
That's what this is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Ms. Boone by the overt act. And the overt acts, I have to tell you, his hand is coming out of the suitcase. That means he's about to get out of the suitcase. Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence because there's a picture provided of Mr. Torres's hand that shows a mark on that hand that it matches up with the bat. That's the overt act. It's like a gun, okay? You don't have to wait for them to pull the trigger. You don't. And it's based on all the evidence in the case, just not testimony, but also physical evidence.
This guy is a freaking whack job. Oh, the defense attorneys give the judge, well, I don't know what else to say now. A lot. Maybe cite something, get Margaret on the phone. Oh, God. I saw a hippo take a dump once, and it was never-ending stream of feces existing while his tail flung it all over the place. This is what we're watching right now. Oh, I'm glad I took you guys like you were joking. And I'm so glad I waited to watch this with you guys, because this guy is... Oh, come on, man. Sit down. Just sit down. There's a picture Come on, right? Let's see that picture. I want to see that picture. Thank you for the wet money bundle. Sure, has worked as a zookeeper years ago. That's why we were knee-high boots everywhere like this, a giant bomb of poo. Yeah, we all should just be wearing chest waders right now because I'm bringing a shovel, especially with this trial. There is no possible way for him to get out of that suitcase when it's zipped up like that, and she's afraid for her life, right, Leah? Oh, I cannot believe I just heard a lawyer say that's an overact. Oh my God. What a...
That might support the testimony.
Thank you, sir.
I got it.
All right, the court has had the opportunity to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part. With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279. No argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110. Rudin, R-U-D-I-N v. State, 182 Southern 3rd, 724. State v. Woodson, 349 Southern 3rd, 510. And Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records is relied upon in Roberts v. State by the 6th ECA in May of 2023 WL 3262633 at Pinpoint Site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in Ladd 564 Southern 2nd 587 has been established. Any questions with regard to the state's ruling? I'm sorry, the court's ruling. Forgive me. Defense.
Meaning,
you want to mention an opening? You can mention an opening. Certainly, I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire. And even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection. As to should the defense put on a case, the predicate under Ladd needs to be established before any expert opines to battered spouse.
my concern is open. Can it be mentioned in?
Yes, that's your decision. That is your decision if you want to mention an opening. There's no preclusion from you doing that. Okay. Any other questions?
So what I heard there, guys, is she's going to be early on the stand, early, because they cannot bring in the experts until she testifies to it. So she's going to be one of the early witnesses. If I've heard that wrong, please correct me, but they can't bring the expert in until she testifies to it. So she's going to be early on in the case in the defense side, obviously. But wait. State's got to put their case on. How are they going to put their case on if they think she's going to do this without, they'd have to have a rebuttal. Yeah. There is tired, and then there is sick of Sarah's shit. Yeah. How are they going to do that? I guess the state will have to basically put on a case and for her to, because the state goes first. If the witnesses, I guess they'll just have to, well, then that means that, sorry guys, I'm talking this through in my head here. If she testifies, Deb says, if she testifies early, she cannot tailor her testimony before she hears everyone else's testimony. She would have to, because, well, not have to tailor. What I'm saying, Deb, is she's going to have to go early for them to bring bring the experts in. Not yet, Leah. Not yet. Happy Rabbit. I'm going out on a limb here. I don't like SB. No. State can have rebuttal, I think, but their cross of Sarah will destroy the defense. Yeah, so you're right. I'm overthinking. But she's gonna have to be probably the first one called for the defense. She's gonna have to be the first one before they can bring their witnesses in. And they're not going to want to bring all their other witnesses that they say they have in because they need them to talk about the domestic violence. She's going to be the first on the stand for the defense. That's interesting. Deb says, no, Leah, they are still asking questions to jurors. I know she needs to go early, but it will be detrimental, I think, to her case. Absolutely. But they've just stepped in it, right? And the judge almost kind of just forced it by them not being able to call they can call their experts, but they can't talk about it unless she testifies to it. Nice job, Judge. Nice job.
Questions with regard to the court's order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you. Moving now to the defendant's motion in limine filed October 6th and the state's response to same. It looks like we've reached some level of common ground with regard to that motion. The court is going to grant the motion with regard to the statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Kopsel and Miss Boone from page 69.
Should be done tomorrow. Maybe we could have opening statements tomorrow afternoon, or it should start Thursday. And thank you, Sky Troop, for putting that in earlier because I was unaware.
Line 6 through page 71, that will be granted to the state not objecting to same. That leaves us to the statements on page 53, line 11, 53, line 13, line 14, page 55, line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all the case law.
I believe the state witnesses here, we would like to vote.
Okay.
The rule of sequestration applies to testimony of other witnesses.
Thank you, Deb. Tomorrow is Thursday, by the way. Okay, so we could have opening statements tomorrow. I don't, this judge really wants this over with, so I'll look while we're in this. I'll pull it up and see what's on the docket.
Not to anything else.
Response?
Not from the state.
He's allowed to be here to watch. I understand, but I want to know whether she's going to testify.
I said there's no state witnesses.
So that's a no. May proceed with any argument, Mr. Owens. Yes, sir. I have reviewed the 2.8 instruction prior today. Thank you, Counselor.
Judge, the problem is the state attorney, when they filed the response, they didn't include the highlighted portion that's italicized at the beginning. Police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury. That section, which is comments directed to the court, was not placed, to my understanding.
Owens, give me a minute. Look at the guy, you have no idea. Look at, they put forward another motion today, a different motion. Good for you, Judge, for putting a stop to the idiot trying to argue with prosecution. Owens is getting more frustrated than Sarah. Yep. I don't think Jay and Owens like each other. Also, it may be one-sided on Jay's part. They put forward another motion. Defendant's objection to state's digital exhibits. This went in at first thing this morning. And it's all different images. I wonder if one of the images of the hand outside the suitcase. Oh gosh, I cannot believe he said that. I truly can't.
In their response.
Okay. Any other argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event. And the day prior to this time, or that morning, the detectives uncovered the 2 videotapes, the 2-minute video that Sarah Boone had recorded, and then followed up 11 minutes later with a 22-second video that she recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder. They spent 2 hours trying to do that any which way they possibly could. And the law says that they're allowed to use, and I cited several cases, cited the Smith v. State case, the ODEH, O-D-E-H v. State case, and the Eugene v. State. And in those cases,
I didn't see a citation to Eugene. I mean, Eugene's included in ODEH, but I don't.
Eugene is found, do you need the site?
I have it. It's included in ODEH, but you did not cite it in your motion.
Okay. Eugene is 53 Southern 3rd, 1104. But law enforcement are entitled to use a variety of interrogation techniques to try to elicit a confession to the crime. But as in that case, in spite of the detective's efforts, Sarah Boone refused to admit that she was guilty of the murder. But as a last resort, Judge, and it was a 2-hour interrogation, it was the last portion, at least the last quarter, it may have been less than that, is when the detectives made some statements that are highly prejudicial to the defendant and tend to be opinion and tend to invade the province of the jury. And that's why this special jury instruction 2.8, recorded interview, effective law enforcement statements on the defendant, has that italicized portion in there. And the statements we're referring to under my motion, the second section of evidence to be excluded, page 53, line 11, well, he's dead as a result of your actions. And then paragraph 9, line 13, he's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question. You realize you're the person that killed him, right? Sarah Boone responds on page 56, I thought about that. And then lastly on page 92, well, intention or not, here's the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. That is exactly the kind of opinion testimony from law enforcement that the courts are worried about. The probative value of that type of opinion testimony about her guilt is outweighed by the prejudicial effect. Thank you.
Response.
State stands by the case law that we cited and that the jury instruction.
2 hours doesn't seem that long for an M interrogation. No. Just repeating himself, wasting time and money. Absolutely. Irene. Are you new here, Owens? We all know law enforcement has the legal right to track a person, and we've been over this. Yeah, and I believe the video in this, let me see again. Images. And then there's 1, 2, 3, 4, 5, 6, 7 images that were, I guess, deleted, that have been pulled up. That's insane. It is not an opinion when they are just stating what happened and Sarah was the person responsible. Fact. Absolutely. I have seen where interrogations have gone for 12 hours or more. Yep. This is just a lot of nothing with this guy. A lot of nothing.
That would be read. I didn't feel it necessary to include italicized portions of comments to the court because this is what would get read to the jury. Those statements are designed to get responses from her. They did get responses from her.
Let me ask this question first, Mr. J. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
To the extent that he is making the argument that they're expressing an opinion about the
No. The words, not his opinion, not his thoughts or what it means, but the black and white verbiage is reflected in the motion. Is that what's reflected in the recording?
I'm accepting that he would not misrepresent that to the court.
Okay, thank you. You may continue.
And as far as the last line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement. He's not giving an opinion on the law. He's giving an opinion about her reactions to this interview and trying to get a reaction from her when he says, well-intentioned or not, Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to whatever the court's ruling is.
Okay, thank you. Any rebuttal?
Just for the state attorney not to put that in there, the italicized portion where Supreme Court is giving instructions to the court with those comments. For them not to put that in there, I disagree with.
Okay, well, the Jackson case speaks for itself, and the court has reviewed it.
Thank you.
All right, thank you both for your motion, your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response, that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion, as under the Bush case cited by the state, law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that this is the expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted, and those will need to be redacted from. I apologize. Thank you. The defense's motion is granted for those reasons. Any questions or clarifications with regard to the court's ruling? State.
Oh,
Questions or clarifications with regard to the court's ruling? Questions or clarifications with regard to the state's ruling? Or the court's ruling, excuse me. All right, that takes us now to the state's objection and motion in limine to exclude decedent's medical records. I've reviewed that as well. State, you may proceed.
Judge, just the other night, I received 550 pages of medical records regarding the treatment of Mr. Torres from two incidents, one in 2017 and one in 2018. A third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I had not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes.
Yes.
And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider. Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment. That narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive and it's going to be confusing. They don't need to read 57 pages of all of his treatment. The second batch was 487 pages regarding an incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that he, the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident, it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know that the 187 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience.
Oh, I see what the defense is doing. Oh, I see what they're doing. Owens is kind of clever in a way, if you think. He wants to make George out to be such a violent person that he's even violent with other people. They want to bog the jury down with all these details of this violent stuff to cloud the jury from all this other stuff with Sarah. Jesus.
That are in these medical records. It's unnecessary and it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Judge, as you know, we got on this case about 45 days ago, and I can't tell you how many pages of discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications, which are kind of like emails or text messages. And that hasn't been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages. And they haven't narrowed that down to which ones they believe are incriminating to her.
Understood. But respectfully, that's not the issue for the court right now.
That. But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, Jorge Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes.
Exactly, Rochelle. That's all the defense is trying to do. Speed bumps, roadblocks, and detours. Yeah, they're just going to try to smoke and mirrors to kind of, and that's why I think she's going to be early on the stand, because then the smoke and mirrors can happen after. And wow. Correct me if I'm wrong, guys, but isn't Mo in jail right now? I know one of his brothers is in jail for domestic violence or something like that. Oh, Margaret, sorry, I didn't mean to skip you. Who cares? When he took this on, he knew he had a very short timeline. He absolutely did. And you know what? Maybe he should have turned down his friend and the conversation he had. Don't look here, look over here. There's a squirrel. Yep. Ooh, piece of candy. Ooh, piece of candy. Okay, thank you. I knew one of the brothers, Farrell Torres, is. Okay. I wasn't sure if it was Mo or Farrell. Thank you so much for clearing that up, Irene. Yeah, victim blaming and vilifying George takes the spotlight off Sarah. Yep. And if she's early on the stand, and then they can bring in the experts afterwards and all these medical documents and all this. Jesus, guys. Oh, God. I don't like how this is going. I don't like how this one's going.
Assume before they introduce something, they're going to have to narrow it down. Did y'all not have George Torres's medical records prior to me sending them to you?
No, we didn't.
All right, well, we took the deposition of Dr. Harper, and as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client. But a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on George Torres's medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that, but they were well aware that that's one thing that she relied upon. A lot of that collateral evidence doesn't come into, and it's going to be.
I need to jump into the breach here. I understand all of that. I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the.
Sorry, Kyrick. Dr. Harper, who originally said nothing to see here until suddenly she decided Boone was a victim. Yeah. You know which doctor I wish they would have got? The one from the crazy guy from, I can't remember his name, Spiegel. Dr. Spiegel should have been the one that would just made this whole trial perfect if they would have got Dr. Spiegel. Oh, it would just be he suits this trial. Dr. Spiegel. Oh.
The state pointed out in their motion as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony.
You are the proponent of the evidence. So you have to establish relevance.
I agree.
And you have to establish that it is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40 some odd pages, I think the state identified as that. What of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down?
Irene says, I feel like Kranix is always teaching a lawyer refresher to Owens and Henderson. Yeah, and you know what? He should just say, did you graduate from the Adelson Institute? That's what he should say, because these lawyers are just like rash bum. They're just so out of there. Guys, I'm not liking how this is looking. I don't want to be pessimistic at all, but if she goes first, the state puts their case on. They bring out the suitcase video. Then the defense goes. She goes up first. Then all these experts that are tooting the horn of self-defense comes up after her. I don't like how this is going at all.
since
Well,
we have some level of common ground here.
My case is not going to be presented, I would assume, until next week, so I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay, I can't let you know today, Judge. I'll narrow it down, or we'll talk in the next couple of days.
Well,
by
the state's
Friday.
position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure there. I'm relying on counsel's representation.
I don't know. I'd have to.
Irene says, I think it'll be fine. She's so unlikable. Maybe I'm overly optimistic. I hope so too, Irene. But once she's off, then they're bringing all these experts in. She might not be credible. They might just turn like, oh my God, this woman's batshit crazy, like we all think. But then when she's off the stand, she's no longer talking. You've got all these experts on her side. I don't like how it looks. Sarah has her lies ready to blame George for everything. Yep. And it's obvious Owens has got people lined up. I wouldn't be so weird about it if they brought their experts out first, then her. But if they bring her out first and then the experts behind, yeah. Wow. Sir, you have no time. No, the clock is done ticking for you, mister.
To look at him, but in one of the medical records, George Torres was over a 0.31 BAC. Every time.
In 2018?
2008.
I'm talking about the 2018 incident with regard to the plate
I
glass
have to look at the
window.
records, but there is other evidence in those records that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk, or that's when he does something violent or threatens to do something violent when he gets really drunk. In one of those incidences, he was over a 0.3. When he gets over a 0.2 to 0.3, that's when he gets angry. He's fine up until that point. We're going to establish that. I don't want to put on my defense today, but Judge, there is going to be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay, what about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. You know, it's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction, surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
That's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find based on that whether or not that's relevant and probative to the case.
That's not how motions in limine work.
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
I'm struggling with understanding how I can understand BAC results. I can understand that based on Dr. Harper's deposition.
Top says, yeah, but the experts can be cross-examined by the state. Yep. And then Owens has recross, right? So, geez, guys. Deb H says, Sarah has to testify to an event that threatened her life to cause self-defense before experts testify. If Boone does not establish that with her testimony, she cannot bring up battered spouse, right? But you know she's going to establish that. That's a given. She's going to say whatever she needs that defense. This is insane.
I can understand the narrative as to why they were there. I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017?
Yes, he is.
How is it relevant?
Some of those may not be, some of the records may be relevant, depending on Sarah Boone's testimony about how what happened to him was tied to what he did to her.
Okay. Anything else?
That's it.
Response?
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use in trial. So for
Top says, sounds like Sarah's going to claim George got aggressive from the beating he got. Right? Oh God, I just want this trial over. Like, Sarah Boone's been in all of our lives for over 5 years. Enough's enough.
For them to come in today on the third day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong. They got these records, and I understand that they're the 9th set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021. And they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Miss Boone's box, apparently, that Billy Lane had acquired years ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both, and the state too, we both just.
B Rabbit says, but didn't SB say in the not intentional interview that neither of them had much to drink that day or night, what is it, SB? Absolutely. Like, to me, it's a huge win for Owens to put her up early, then put all his experts on afterwards. It's a huge win for Owens. She is pestering Owens and is unhappy with all of this. Yeah. It cannot be self-defense if Sarah was initial instigator. Cops usually arrest the one who started it. Yeah, and many times George was the only one that got arrested. So is he saying that it gives her the right to beat the shit out of them, toss him down the stairs while he's in a suitcase? Leah, I have no idea anymore with this case, honestly. Hey, Rhodes Scholar, welcome back.
Disclosed, what are we actually introducing? The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was. And
oh, no, I know that, Deb. I know the state gets to cross-examine Sarah will tear her story apart. I agree. But if they put Sarah up early and they do all this, and then they bring in the experts and all this smoke and mirrors stuff, are they going to be able, with the smoke and mirrors, get the jury so confused and pull the spotlight off of the crazy that is Sarah Boone? Ooh, I don't like it.
handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here. We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10-15% for legal blood. At the time that he was admitted for his facial.
Sarah Boone wants everyone to enter her alternate universe. It's a hard pass. It's a hard pass for me to be. That's a rabbit hole I am not going down.
Facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something.
Yeah, Sky Troop says, remember, Crime and Coffee, the suitcase videos are in and are all it will take to convict. I agree. And that's all coming in on the states. I don't know. Maybe I'm underestimating the jury, that they'll fall for the smoke and mirrors. No, don't worry, because all the other evidence doesn't support self-defense. I agree, it doesn't. I'm just worried that the jury is going to fall for the smoke and mirrors. And if all this is put on early, like the suitcase is going to be put on early, all of that, and then all these experts come on behind it, Skytroop, those videotapes is all they need to convict her. I would agree. Wonder if Owens and Sarah's suit jackets were bought together. Buy one, get one free. They are very close, and it is gray. I thought it was black for some reason. And more goodies to come in evidence. I guess I could be underestimating a jury, that they aren't going to get tricked. And those videos will show jury how drunk she was, and she lied to investigators about it. Yes, Rochelle, don't be such a pessimist. I just worry that the jury's going to be deluded with BS. And all it's going to take is a few to be like, go hard on the DV. Oh, God.
Something that triggers one of his brothers to violently beat him nearly to death. What his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day. And that's just not my understanding of how the deposition's read. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning. Thank you.
Thank you. All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the December 24, 2017 incident and the 2018 incident, I find potential relevance. So I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. Yes. I'm not foreclosing you, but there needs to be something for you to link these documents together for me. All right. Any clarification or questions with regard to the state's rule or the court's ruling?
Top says, trust the jury has common sense like us and won't be fooled by her. Only 6 jurors, easier to get conviction. You're right. I just feel very pessimistic about it. I don't know why. SB is unlikable. Her testifying will ensure she's found guilty. Well, I almost hope that they make up their mind then. I know they're not supposed to. Be positive, be happy, no worries. Sarah's long-term placement will be prison. Hello, Marie. Welcome. Why is there only a 6 juror instead of a 12, or did I misunderstand something here? No, they're only running a 6 juror. 6 juror, and I think Joel said today there was like 9 alternates, something like that. It's crazy. I don't get it. I don't understand why it's so different everywhere. Sarah stares. She could be in Stanley Kubrick movie, chilling coupled with her smile. Yeah, completely evil. Oh, okay. Thank you, Deb. In Florida, I think they use 6 unless it's a death penalty case, but Charlie had 12, and that wasn't a death penalty case. It's weird. I've noticed in all different courts throughout Florida, the ones that I've watched or followed, they run them completely different. There's nothing like, look at friggin' Wade Wilson. He was allowed to go up to sidebars. Oh, okay. Thank you, Top. Thank you very much. It's because it's a second degree, not a first degree. So first degree is 12. Okay, that makes, see my above comment. Thanks, Top. Thanks, Margaret. Yeah. Okay, so that makes complete sense to me from the trials that I've watched then. Thank you so much. Gotta love my American friends. All right, we'll get back.
Defense. All right, thank you. That now takes us to the objections to the evidence. Give me a moment. We have the defendant's objections to state's digital exhibits filed October 15th. The state's state's response to defendant's 5th amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, etc.
Oh, yes. Sorry. I'm sorry. I meant, yes, my Australian friend too.
Are. It just identifies them. I'm not sure what it is that they are.
It's tracking their 5th amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph 1A and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item, tracking their 5th amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's 3rd amended exhibit list. When was the 5th amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of some pleadings, but they're not bait stamped with the clerk of the court's e-filing system on the top left. So I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a 1-page document. So it's hard for me to say what, I know you may have seen it, but the court hasn't seen it based on what's been filed.
I believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay. All right. I need clarification, Mr. Owens, as to when the 5th amended reciprocal discovery exhibit list was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything for me to line up item 1 and item 1 as to what they purport to be.
You're asking for when it was filed? We're checking on that. When it was filed. What was the next question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's third amended exhibit list. And it's just that. What we intend on utilizing has been provided. But I don't have anything else as to what those items are.
Okay. Did you want us to provide you with a copy of those to your JA?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else and let me get.
Unless we've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second.
I'm shocked she's even allowed to do that.
Okay. All right. I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel.
Oh God. I bet you would like to move on. Sit down, Jimmy. Sarah wanted to be involved 100% in her case. Owens is just her puppet and figurehead. Yeah. I agree, Deb. Back, jury will see the videos and it will be over for Looney Boone. Oh, God. This trial. Like, honestly, I thought, oh, no, we're not going to have... I still wish we had a pro se Boone, but I think we're going to be in for a similar show, even with Owens at the helm. Oh, God, this trial is going to be something else.
No, I'm sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID, and jury services has instructed him not to return. Juror number 551.
What was the first one?
Sure. Juror number 471, panel 3. That would have been yesterday morning, seat 48. Advised jury services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed jury services to excuse him because we don't need that floating around. The other juror, 551, I don't have any other information as to what panel or seat. She took a COVID test and was negative. She is planning on reporting today. So due to the shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here. That's the only other housekeeping matters that I have to address. So are there any housekeeping matters to address from the state before we address the objections issues?
Is it wise to not utilize that expanded space when two of these panels, or at least one of these panels, has already been exposed to COVID up in the 23rd floor? Would it not be wise to use the bigger space in 23 since one of our panels has already potentially been exposed to COVID, as opposed to packing everybody in like sardines?
Response.
I don't know.
Yep.
23, so
Can you all approach this for a second?
Oh boy, are we going to have a delay because of freaking COVID? Come on. I've been saying your name wrong this whole time. You're such a nice person. I've always been saying Armand, and it's Armand. I just wanted to correct myself on that. Oh, I was right the first time. Armand. Okay. Then I correct myself again, correcting myself. I've been doing that a lot this week, correcting myself. I'm worried about the prosecution. They do not look strong at all. In fact, they seem very weak to me. Oh, really? I'm not worried about them. I'm not worried about them. No, COVID is not an issue. They continue. I watched the afternoon talking with jurors. Oh, they had the jury selection. They were streaming that because they said they weren't going to stream the jury selection. I believe they will speak for themselves. I believe that. I'm just worried about the jury. That's all. Armand, I got confused there a sec. Armand is common name in my community, and I panicked. I said, "Am I mispronouncing it all these years?" Sorry, guys. Yes, got to hear the questions of the
All
jury.
right, court's going to take a 15-minute recess to address jury selection location this afternoon, and to give the defense the opportunity to provide the fifth amended exhibit list. With regard to juror 551, what say the state?
No objection to the, if he doesn't have COVID, then I don't have a motion for cause.
Okay. Any response from the defense?
That's you, Owens.
Correct. That is correct.
Anything in addition to how she was feeling?
I read you what was provided to me.
I have no.
Okay. Court's going to be in a 15-minute recess. Thank you.
Oh, thank you, Sky. I missed that question. Sorry, Jane. She is so narcissistic. She's going to dig her own grave. It's going to be a show for sure when she's on. No, per se, Sarah. She'd be strutting around the courtroom. It would have been hilarious to watch. Production was streaming through someone else. Oh. I'm going to have to find that. She might have it on her recorded show. Okay, well, we don't have to take this break that they're taking. Okay. Right back.
You ready? We're back on the record. 2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Kester on behalf of the state. William J. for the state.
Defense. Ms. Boone is still seated at counsel's table wearing the same gray suit and white blouse from this morning. Can you all approach?
I agree, Marie. I think if she did not stupidly make those videos, she might have had a prayer. Still, the whole putting somebody in a suitcase and closing it, she's thinking, I just love the gals on my team. Yeah. Look, she acts like she is a lawyer. They even got her a new, oh, look, she's packing up, organizing. She thinks she's second chair or something. This woman does my head in. She knows where all the cameras are. Can you imagine if she was allowed to go up to sidebar like Wade Wilson did? Oh my God. Yeah, she did, Murray. She actually videotaped her own actions so very clearly and verbalized her disdain. I agree, she's smelling a lot. B. Rabbit, it seems to me that SB has just disrespected the court system from the get-go and has not only got away with it, but state-funded lawyers are enabling it. I'd be furious if my taxes funded this shit show. I would be, oh, B. Rabbit, I'm at. Owens won't be able to find anything on the desk now. I know. I'm like, I hope he didn't have that organized because she's messing it up. Rochelle, can you please break down the motions that Sarah won? She didn't really. Yeah, we'll talk about it after. Yeah, she's organizing and reorganizing over and over. Yeah. She didn't really. Yeah, she is, Armand. She is loving every minute of this. It is all about her playing it up for her fans. I wonder if she's going to get Boone husbands. Yep, she is. She's acting like she's the lawyer. Let me pull up and see if they put their court states. Oh, that's funny. The court hasn't even put in their minutes yet. They're probably just as confused as the rest of us. I saw Sarah's pick in the dictionary, arresting bitch face. She's pretending to organize her paperwork like a true attorney.
All right, court's going to step out for 1 second, and then
Here we go.
you can email that exhibit list to Madam Clerk, and then we can go from there. Thank you.
Why are they having people step out? Or he's just going to step out for a few minutes. Jesus. It was more than a few minutes. I'd love to think that her bunkmates in jail messed up her paperwork.
All right, we're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State, let me get appearances.
William J. for the state.
Defense. Thank you. Ms. Boone is still seated at counsel's table with the same clothing from this morning. All right, I've been provided by Madam Clerk defendant's fifth amended reciprocal discovery exhibit list. I haven't had the opportunity to review it yet, but it is in my hands. Let's start with the defendant's objections to state's digital exhibits. I'll turn it over to you, Mr. Owens.
Hi, Mary. Use the mic.
Correct. But the same problem I have is it's just the notice of provision. I don't know when any of the substance was. All right, you may proceed, sir. Okay, go ahead.
And Judge, this was a little bit of a new procedure because what I did was review the images and these, as in the motion, we object to all the cell phone photo evidence. The state intends to introduce a trial as to, I'm not going to know until I hear evidence or see when they're trying to introduce it, if it's relevant or not at that time. Something might make something relevant at a certain time, or it might not make it relevant. So there. And also as to just the foundational stuff, because the images, as I've seen it, I don't have dates. So I don't know when it was taken in relation to the February 23rd, 2020 date, which is the date of the offense. And so I'm at a loss for that. So I don't know if it's 2 years before, does that make it relevant? If it's 3 years before, I don't know. So that's going to be, if the foundation is left.
So there. Oh my, so there. And what happens when a relationship breaks down with these attorneys? It's a matter of when, not if. I agree, B. I agree. Right, Sky? So there. What is wrong with the truth? We are fighting all day, got drunk, and played a nasty drinking game. Yep, but it was a good day. It's not intentional.
Played. That's my problem with these photograph exhibits is I don't know until I hear who's trying to put it in, how's it identified, and if the proper foundation is made to make it relevant. Okay.
Response?
He means business. Oh gosh. He's pissed. He is. How could it not be relevant? The date and time is on the phone, but that wouldn't matter. You are watching her kill her boyfriend. Yeah. Yeah, it's disgusting. I wonder how much the taxpayers had to pay for her hairdresser no hairdresser, no makeup artist. I would also be very upset if I was one of the taxpayers there. Yeah, no, she didn't get a hairdresser or a makeup artist. That was denied the last time, and it was not, the judge didn't really deny it at first, but the sheriff did, or sorry, court sheriff, or said that she couldn't wear the makeup into jail because they wouldn't be sure of contraband, which I think Owens really dropped the ball there, because he could have said it could be washed off before she goes back, but he didn't. On my bingo card is no malicious, and know this. There you go.
Is this going to be considered a separate hearing for the record? So should this be D or should it be A?
Everything was, when I called what was being heard today, it was all in the same hearing. So I
That's
believe
right,
it should be
guys.
pre-marked as D.
What I'm having Madam Clerk mark as
Robust
D for
and
identification for purposes of this hearing is what has been provided to the defense as the very narrowed down portion of the phone extraction carve out. What it has is and we were even so specific that we labeled one part of the PDF case in chief pages, of which there are 59. We labeled rebuttal pages, of which there are 108. Attachments that go to the case in chief timeline. Count up as 80 photographs and videos. Attachments and rebuttal.
Marie, I said the same thing out of a Cracker Jack box.
Count up as 147 photographs and videos. There is metadata that comes with all those files. So there is a date stamp and time stamp on each of those files. For instance, 12/25/2019, 1:10 p.m. Another one might be 10/26/2019, 6:06 p.m. They all have file names. Providing context would be the PDF Outlook.
Did any of the motions succeed over the past hour? I wouldn't call it succeed, because there was the judge would side with, sorry guys, the judge would side with the state and the defense at the same time. So part of it would be allowed and not a lot of it's going to come down to her testimony, if things are going to be allowed in or not. It's now Sarah Boone, Esquire. Yeah.
Our PDF outline of the phone extraction, of which the state will now move into evidence so that the court consider this as states 4 for the purposes of these hearings.
Any objection to what was pre-marked as D? All right, that will receive without objection as states 4.
So just to give the court an example. On page 49 of 59 of the PDF labeled case in chief, entry 31107 in this PDF from the phone extraction is labeled videos, 2/23/2020, 11/12.
Sorry guys, Leah, yes, Owens is the lead lawyer.
PM 45 seconds, UTC -5, which means corrected to Eastern Standard Time for that time of year. And it's image_1062.mov. So that sort of information is going to be there for the majority of these files. The ones that end up getting recovered from unallocated deleted space are sometimes not going to be there. But there will be contextual clues as to their relevance. The court will be able to see that. So for instance, that image is the 2-minute infamous video of Mr. Torres being in the suitcase that started at 11:12 p.m., 45 seconds on February 23rd. So there is context that can be used both on the metadata that's in the file when you
Leah, they said it would have to be done at defense table, so they just didn't do it. Jane says Daryl Brooks had us in narc hell too, but we always get the last laugh. Know this yet. Whew, sorry, guys. Infamous.
list these files by details instead of by icon, and then within the timeline. And what we have carved out is the case in chief timeline has a conversation that begins on Christmas of 2019, and it starts with Mo, presumably the decedent's brother, having a conversation with Sarah Boone, the owner of the phone, and it culminates in hide and seek, I shall. That's the context of that conversation on December 25th. Then it goes down to conversation that's going on January 12th into the 13th of January of 2020. Culminates in a text from the owner of the phone saying, "And bless you and all of you too, I'll get capitals rid of him." So that's the context of those portions of our case in chief PDF. And then there's just the timeline that starts with February 23rd, 2020 at 8:35 in the morning and goes through the entire day to give context of what is going on with her on the phone. Is she using it? When is she presumably awake? That's the context of that file. The rebuttal file, which is, again, 108 pages. It starts, and it basically involves with conversations with or about the decedent, conversations with his family, which I anticipate the defendant is going to testify she was terrified of, and there were problems with all the time. It's going to give some context to those things. It mentions when they became a relationship on Facebook of March 8th of 2018 to give context as to when perhaps this relationship started or not. And then there's a timeline that starts from May 21st, 2019, that is filled with conversations about and with the decedent. At that point in time, he had his own phone, and then at some point he doesn't. And the discussions and the arguments between him and the family with the defendant. And then the images that are associated in the folders, case in chief and rebuttal, are the ones that are associated in these time frames. I have cleared out the vast majority of them. The vast majority of them were just icons and things that belong to games and nonsense. I cleared out all the photographs of Mr. and Mrs. Boone's child, any of that child's friends. There was no.
Sorry, I'm just going to pause. Deb, if you have the link to the afternoon, the questionings, could you post it for me? I know, Armand. We will, as soon as we stop, I'll go back. This is just baffling. Sorry, guys. I'm having a little bit of a rough night. The afternoon.
No need for any of the pictures of the children. It's mostly photographs of the decedent and the defendant, but there's also just pictures of art and them going out because it gives context. if she's in the middle of an argument, for instance, with the family, one might expect there to be pictures of injuries. Instead, there's pictures of art. So we did our best to select which photographs and videos were pertinent within these timeframes. We did our best to narrow it down to what timeframes we believe will give a good rebuttal picture after she testifies about his family and her relationship with him. So that's where we're at. So as far as the general relevancy objection that was made, there was no specificity as to what particular entries in the PDFs are objectionable for any particular reason. We believe that everything is relevant. Again, we are submitting it for the court's review. I know that we're on the third day of jury selection, which will apparently resume in 81 minutes. If there's an authenticity issue, because one of their objections was relevancy, foundation, unknown origin date, hearsay, and Crawford issues. I'm submitting for the court, if I can approach the court. Gilbert versus State, 324 Southern 3rd, 598 from the 2nd District Court of Appeal, decided in 2021. Lamb versus State, 246 Southern 3rd, 400 from the 4th District Court of Appeal, decided in 2018.
Thank you, Deb.
Gale, Gayle versus State, 216 Southern 3rd, 656, 4th District Court of Appeal case as well in 2017. The basics of these three cases are just a very low bar for authenticity. As Professor Earhart from Florida State University would tell us, authenticity is a very low bar for the court. It is generally considered a matter of weight for the trier of fact. And with this digital evidence, it can be established and authenticated in a variety of ways. What the state expects the evidence is going to be is that the defendant's phone was taken from her home by law enforcement, as we know from the motion to suppress, and it was provided to a digital forensic examiner who was able to use the defendant's passcode to unlock it and perform a digital extraction. So that should clear up most of the authenticity issues as to who the owner of the phone is. The state readily concedes and has provided context by using extra pages of conversations that at some point the decedent no longer had his own phone and was using Ms. Boone's phone from time to time. And in fact, that is part of her allegations about pornography and contacting other women. But I believe the context of those conversations makes it clear who is using the phone and who is not using the phone. So we believe that there is no foundation issue. We believe, based on the defense they are raising, that there is relevancy. We have split it up to the case in chief and the rebuttal. We are specifically only entering the two incriminating statements in the context of those incriminating statements about hide and seek and getting rid of him, plus the timeline of the date of the offense. Then the rebuttal, we have carved it out as best we could to present a picture of the conversations and the tone, as much as tone could be inferred from texts, and how the relationship was with the family and who may or may not have been the psychological aggressor. As far as hearsay and Crawford issues, I am unclear if they are talking about just in general the digital forensic extraction report itself. One of the cases I gave to you makes it clear that machines are not humans. They do not get subjected to Justice Scalia's version of the confrontation clause that he outlined in Crawford versus Washington in 2004. What he also talked about, though, and what has had some discussion since the Crawford decision, was what's hearsay versus testimonial hearsay. Obviously, there's no testimonial hearsay in these phone extractions. There's no implication that any of these statements made by any of the participants' text conversations were doing so with an eye towards litigation or prosecution. So it's the state's position, number one, that the extraction itself and all the data that is coming from it is not hearsay and is not testimonial hearsay, much less. And the conversations that are going on with the other people, the statements that other people are making back to the defendant in the carve-out that we've provided aren't being offered for the truth of the matter asserted.
I just posted the link to the channel that we're going to be reviewing after this. Please go over, like, share, subscribe, show our gratitude. Marie says this was premeditated. She planned this. Should be first degree, in my opinion. Well, that one comment that I just heard that I went, what? That sounds like premeditation to me.
There is no hearsay issue. It is to provide the context of things that the defendant is saying. I'm going to go bond Jorge out. I'm going to go to the public defender's office and get this taken care of. Or screaming at his family, so on and so forth. Demanding immediate responses when somebody's cutting hair and keeps on telling her repeatedly, I can't respond to you. Can't respond to you, I'm working. So those sorts of things, it's the state's position, aren't being offered for the truth of the matter asserted. As far as the unknown origin date, I think it's pretty clear from the PDF timeline that.
Armand, where did you see that? STS has it. Okay, I'm going to try to find it here. Has she not seen the social media wave of disgust with her? Probably not, Jane. Geez, where would that be filed? Where would Charlie's? Just trying to think of where, because it's not going to be Leon County. I don't know. It might be, because that was where. Let me just go into Leon County docket here and see if there's anything under Charlie Adelson. Because this conviction was out of Leon County, so there might be something. Nope. I don't think all his mom's issues with Rashi can be used in his appeal. There is nothing. What the heck? Where would it be? Maybe my American friends can help me. Where would an appeal be placed if not in the county that they were convicted? Because that don't make sense. Why? Oh, wait, it might be under Charles. Charles Adelson. Okay, Charles Adelson. Let's go down to the date. Let's go here. Yep, there it is. Record of Appeal Supplement. There it is. There it is. Okay. I won't bog us down. Let's finish Sarah. Is she that aware? Is she that? Yeah. Sorry, guys. I'm just, Marie, it seems they claim an unfair trial because Donna could not be called as a witness. Are you kidding me? She said she was taking the fifth. Because the state wouldn't give her immunity. They told the defense to call her, and she said that if the defense called, she was taking the fifth. Oh, you got to be kidding. This is a bunch of game that these people. I have the appeal up, guys. We'll finish this and then we'll go over the appeal. Unless you want to go over the appeal now, just let me know. She said it was unfair. The media knew more about her case than she did and said awful things about her without knowing her or full story. She said, what does she have to do with the appeal? Or do you mean he said? Maybe. Yeah, they called Donna and Harvey and they committed contempt of court by refusing. Yeah, that's just weird. Armand, about the Delphi murder case and Richard Allen, they have a jury of 12 and 4 alternate motions tomorrow, and the trial starts Friday. Defense diaries and lawyer Lee are going to the Delphi every day. Nice. Yeah, but what? I don't understand what No, Sarah, Rochelle. Oh, thank you. We got 3 different cases going on here. Delphi, Sarah, Charlie. Jury is sequestered. Wow. Wow. They don't usually sequester jurors. Nice. Okay, we'll get done Sarah here and then we're going to jump. Got to see this.
There is a date and timestamp to every single entry from this phone extraction, and that corroborates with the images, most of the images, some were from unallocated space, but it corroborates the metadata for these images. So we're asking for that their motion or their objection to be denied preliminarily. Obviously, we have to lay the predicate properly at trial, but now the court has a copy, and hopefully we can get advice from the court if the court is believing that there are sustainable objections before we swear in the jury.
Delphi trial. OMG, Charlie might get a new trial. I'm suspecting he does. We're not going to be done with the Adelsons for a very. I'm going to be 6 feet under by the time the Adelson trial's done. Honestly, at this rate. Yeah, Sarah's. Where'd it go? Oh, my thing just skipped here. Yes, Sarah's lawyers don't look happy. No, they sure don't.
So that the state can pull any photographs or videos, or we can have at least a discussion about those specifics. And then after discussing those specifics, the state can pull those out before burning a DVD to provide the jury. We also have the ability to black out entries in the PDFs. Again, no specific objections were made, so it would be our position that they're waived. There was a generalized objection, but so that we're not doing this when the jury is out. Trial is busy enough, trial is tedious enough to not be conducting discovery and doing redactions during the nights and mornings of trial.
Thank you. Response.
Judge, I think this procedure calls for a lot of speculation as to the defense part, as to what these photos, examples of the photographs, what's the use of this photograph? There's a piece of art on the wall. I don't know how that's relevant to the case. So without knowing how it's relevant and what their theory is of it being relevant, I have to form the objection. I don't think this is relevant.
What's your response?
Charlie will be convicted again. Truth don't change. Sorry, guys, I was coughing. I agree. He'll be convicted again, but this whole thing that this freaking states is doing one at a time just delays the process more. Round up the Miami Adelsons and try them all together. We'll get 4 different stories. That's what I round them up. One of them's flipping on one of them. That's what I say. We know it's not Donna flipping. And if Charlie gets a new trial, watch out, Wendy. Watch out.
Response to the lack of specificity, that these are just boilerplate objections to all photographs, all video.
Yes, well, they're not to all photographs and all videos. There are things that we list.
It is an objection to all cell phone photo evidence the state intends to introduce. It
Correct.
is objections to all cell phone video evidence the state intends to introduce.
Because at this point in time, Judge, I can't tell you what the independent objection would be. I don't know how it fits into their theory of the case. That's called.
No, yeah. I'm not going to lie. Yeah. I said if I wasn't watching the Sarah Boone trial, I'd be trying to watch as much as I could on that Delphi trial. Sorry, guys. This new medication I'm on is kicking my butt. It's lowering my immune system. I hope Charlie flips on Wendy so he will have a different sentencing. Yep. And if he gets a new trial, he's got a whole new option. Whole new options. And there's the apples. Judge, I'm objecting, but don't know why. Right, Armand? This is insane.
Calls for me to speculate how it fits into their theory of the case. How can I do that? If they show you a picture, like a picture of artwork, all right, I don't know how that's relevant to this case, or a conversation that takes place between 2 other people. At the time, I don't know how it's relevant to the case. So what am I supposed to say? No objection to it? And then am I later barred from objecting to it when I don't think it fits, so they hadn't laid the foundation to get it in? It's putting the cart before the horse.
That pertains to the rebuttal evidence. What about the evidence that was outlined that the state intends on using in its case in chief?
That's it, Judge. How do I know they are going to be able to lay the proper foundation for that evidence? How do I know? That's the thing well, I think the procedure goes like this. Yeah, I could be wrong, but I don't think so. The procedure goes like this. The state has a piece of evidence. They have that evidence identified to someone. All right? They get it marked as an exhibit. Okay, at a certain point in time, the state asks if we'd like to introduce exhibit number 1 into evidence. Defense, either objection or no objection at that time. I've heard the witness who've identified it. I know what it is that time, and I have some relationship to it at that time to make the proper objection. Just getting a picture now, and I'm supposed to say no objection. I don't know what they're using it for. Guess what, Judge? The videos of the suitcase, we didn't object to those. Do you know why? It was clear. I know when it was, and I know the purpose of using it. But when you have animate objects on the wall or pictures of individuals, and in this case,
But what I'm reading, it sounds like you're objecting to those. All cell phone video evidence that this tends to introduce.
correct.
Sounds like it covers the suitcase video to me. All
No, it
means
doesn't.
all.
The suitcase video is listed in the things that we don't object to.
I don't know that. I have image underscore 0954. I don't know what that is. Image underscore 0980. I don't know what that is.
Okay.
I'm just looking at the words on the paper.
How does it need to be done, Judge?
Well, what the
Hey, True. Hey, everyone. Sorry I'm late. It's been a long day. Who is this dude? He is second chair for Sarah Boone. And he is another crackerjack box lawyer.
state is asking for is a preliminary ruling on these objections.
How do you have a preliminary ruling on an objection when the foundation or anything has not been laid in court for evidence being omitted?
State conceded they need to lay the appropriate foundation.
Well,
Part of their argument.
okay.
So I'm not going to address foundation. If they're able to establish it is what it purports to be under the case law, under 90.901 and everything else, I mean, he's right. It's a low bar for what admissibility is.
And I have no problem with that.
Okay.
I have no problem with that part, Judge. The thing that I'm saying is, I want to make sure, because I didn't object to something on here, it waives my right to object to it later.
Okay.
That's what this sounds like to me. It sounds like this is a situation, well, Mr. Henderson, you didn't object to this on the state's list of exhibits. You did not object to it. You can't object to it now. I don't think that's fundamentally correct. So I don't know what part I'm missing.
Anything else, sir?
Well, yes, Judge, I would like, because I know it's a different jurisdiction. People do things differently, okay? 30 years, I've never had to do this in a criminal case, okay?
Part of the reason the court issued the order back in August is at that point in time, Ms. Boone was representing herself pro se. And we needed to establish deadlines to prevent any ambush or last minute issues. Then y'all parachuted in on August the 30th.
Yes.
There was no order. There was no request to vacate any of those deadlines. So those deadlines were still in full force and effect.
Yes, sir.
But the reason behind that was because Ms. Boone at that time was representing herself pro se, and to avoid issues at trial, the court had set a schedule for when certain objections needed to be provided. And I understand your position. I don't want to be in a position where I'm deemed to have waived anything. I get it. But the state's proffer seems to have established some level of relevancy for these things. And as we well know, the bar for relevancy is very, very low. As to foundation, I agree with you. And the state concedes that point. They need to establish the appropriate foundation. And if they're able to do that, I'm not foreclosing you for making objections. But as of this point in time, your objections are preserved for the purposes of trial. You can raise them, certainly. But at this point in time, based on the state's proffer of what they intend to use and why they intend to use it, I'm going to find that it's relevant and not repetitive.
Judge, at this point in time, as a pretrial ruling that doesn't waive my right to object to something as they're trying to admit it based on relevancy, foundation, or any of those things, then I don't have a problem with that. What my concern was, the way this looked like to me, if I didn't make an objection to it at this time for this, I am waiving it at trial.
I understand. Any clarifications or questions with regard to the court's ruling?
We're just, I believe we're trying to treat this like a video interview redaction issue. Like, it takes time to go back and pull out pictures and pull out videos or black out lines or remove pages. That's all we're trying to do is do that today. I don't know what the defense expects to be different at trial, what more information they're going to learn from the digital evidence. I mean, the foundation for this evidence is going to be the law enforcement officer that took the phone that is pictured in the CSI photos out of Miss Boone's apartment. It's right on the nightstand next to the suitcase. And then that person's going to have to testify, well, I gave it to Junella Wadden. And then Junella Wadden is going to come in and bring the phone with her and say, this is the phone that I plugged into my Magic Cellbrite software or whatever she used on that particular day. And this is how Cellbrite works. This is my educational background, blobbity with this software. And I pulled this extraction out. Mr. J sent me this carve out of this extraction before trial. In fact, she picked it up yesterday. And I believe, I'm going to testify that this is part of the larger carve out. This is from her phone. That's going to be the foundation. The rest of these things are things that we should be able to have an intelligent discussion about today with specificity about this line of text isn't okay. This particular photograph's not okay for this reason. That's what we were hoping for.
Okay. Have you reviewed what it is that the state intends on eliciting in this exhibit?
Yes, Judge, this is the things that I reviewed.
Sorry, guys. Did you hear about Liam Payne from One Direction at Crime and Coffee? We had a discussion about the Payne name yesterday. Crazy. I briefly heard it. I was going to look it up. I was going to actually call you later about it. Sarah is demanding that all of their evidence be thrown out. Anything short of them makes them duds and buffoons. Yeah, and you guys are right. They're trying to sneak in the video to be excluded. Leah, I think she will as well. Her personality is such that she needs chaos. She does need chaos. I'm still waiting. I'm still waiting for a reason for this to be postponed yet again.
I sat down last night and went through every one of them,
Good for you,
preparing
sir.
for this hearing. What we did not, or what we failed to do because of the time restraint for the ones that we didn't list the number and I didn't give detail as to like IMG 0954, what it represents. My concern is this, because I don't have a problem with this or with the state's evidence at this time, as long as it's not a bar that when we come into court and I feel something is not relevant at that time, or they go to admit it and I say objection relevancy or objection foundation, then I'm not barred at that time. I don't know any rule that would bar me at that time.
Marie, I'm waiting for it. I'm waiting for it. Once they get all the heavy lifting done and the work done, I'm waiting for it. I'm waiting for her to wake up maybe tomorrow or whatever and think, I'm not trusting this in anybody else's hands. I'm waiting for it. Thanks for making me. I could feel my blood pressure climbing.
Okay. I'm going to overrule your objections for the reasons that I previously identified. You can raise your objections at trial if you deem necessary, but based on the state's proffer, I'm going to find that the different categories of documents that he's identified as reflected in Exhibit 4 are relevant. They are not repetitive. They are not cumulative. And so long as they can establish the appropriate foundation and based on counsel's proffer, seems like they might be able to do so. Any questions, sir?
Now, I just want to add something for the record.
Yes, sir.
The state during its proffer said there were no photos of the child. That's not correct. There are photos of the child.
Jane's just joking.
That are being sought into evidence?
Yes, Your Honor.
State? Response, if any?
They don't even know how to respond to this crap. Oh my God, this is absurd. Oh, she did. I'm so sorry, Jane. I missed that. Mr. J is looking at sports stats, checking for reservations when he gets out of there.
I don't believe so in either of the folders. Don't have any independent recollection if I tied it up more than when I gave them what I believe the exhibit to be a week or two ago, but I don't see any.
Imagine how packed this room's going to be when her trial starts. Holy Moses. I agree, crimes. But they are trying to sneak away so it won't be. They were trying. The state has everything listed and numbered, unlike the defense. Yeah. They are so... Oh, they are not organized at all. Oh. Sorry, guys. I am freezing. I don't think they know what the hell they're doing. Crimes.
Okay, I see two images. I couldn't recognize it as reflection of children in a, I don't know if it's a snow globe in an aquarium or whatnot, but I have no objection to removing those two. I just didn't recognize it as children. I recognize it as a crab.
I haven't seen the picture, so I'm at a loss.
Well,
Mhm.
Sorry,
it's an
Judge.
extraordinary file name, but I'm going to remove those two exhibits that they're
Can I
talking
take care of that issue for you, sir?
I
That
agree.
takes care of that issue, Judge.
Okay.
But the point that I'm trying to make with that and why I raised
Mhm.
it is that there are going to be certain things that I'm not going to know into what is the purpose of it as far as how is it relevant now? They can make a proffer. I understand they can make a proffer, but their proffer isn't evidence. Once it goes up, the witness is in all, and the court has told me that I don't waive my objection, so I understand the court's ruling.
All right, thank you very much.
Yes.
Anything else with regard to the defendant's objections to state's digital exhibits, Mr. Henderson?
No, Your Honor.
Okay. Moving now to the defendant's fifth amended reciprocal discovery exhibit list and the state's objections to same. There are some for which the state has no objections. Those need not be addressed. It will just be dealing with the objections outlined. It is not lost on the court that it is 12:30. We do have a jury coming in an hour. My court staff does need a lunch break. So how do you want to proceed, Mr. J?
I just want a ruling before we swear in the petite panel.
Okay. Do you have any concerns with proceeding with jury selection this afternoon and the final portion of the court's inquiry as addressed yesterday and turning it over to you without having a ruling on these? And we could address these objections tomorrow morning before we bring in the balance of our panel? All right, is that acceptable to the defense? Okay, all right, so then here's what we're going to do. We're going to be in recess till 1:30. We will report to the 23rd floor. I've already advised jury services and court admin that a room is available for us. We will continue jury selection at that time. I will keep you apprised of whether or not we can continue jury selection in 23 tomorrow. As soon as I have that information, I or my judicial assistant will pass it along to you. Assuming we're in 23, we will advise the jurors when they need to return and we can address all these objections tomorrow. And we'll address those objections either in 23 or in 12 alpha. Anything further from the state?
No, Your Honor.
Anything further from the defense? Okay, we will see you all at 1:30 and 23. Thank you.
Okay, let's get to this. I'm going to share the screen with you. No, that's not it. It's not it. Oh, there we go. This is Charlie's record of appeal. I'm just going to make this larger so everybody can read it. I'm going to take myself out, guys. Yeah, do this. Can you please tell me if you can still hear me? Yes. Thank you, Armand. Thank you. Last time I took myself out, nobody could hear me. So thanks, guys. Thank you so much. Can still hear you, Rochelle. Thank you. You guys are great. Crimes Untangled. Yes, I tried to answer with my voice. That's great. Okay, so this is his appeal. Get that address is not off. I'm going to make this a little bit bigger so everybody can see it. Okay, this is just the index of it. Charlie Adelson, case number. The defendant, Charlie Adelson, is being personally before this court represented by Daniel Rashbaum, attorney of record, and the state representation by Georgia Kappelman, and having been tried and found guilty by jury. Murder first degree, conspiracy to commit murder, solicitation to commit murder. If you are a qualified offender, you're required to submit a DNA sample in the matter consistent with Florida law. The defendant, Charlie Adelson, being personally before this court represented by Daniel Rashbaum, attorney, record of the state, represented by Georgia Kappelman, and having given the defendant an opportunity to be heard and to offer matters in mitigation of sentence and to show cause why the defendant should not be sentenced as provided by law. Count 1, count 2, count 3. In the event of the above sentence is to the Department of Corrections, the Sheriff of Leon County, Florida is hereby ordered and directed to deliver the defendant to the Department of Corrections at the facility designed or designated by the department together with a copy of this judgment. Oh, very interesting, Jane. Okay. So let's get to, it's 12 pages, but I want to get to, oh, what's this? Oh, interesting. Judgment for fine, costs, fee, and surcharges. In this judgment and order of the court, the defendant is liable for and shall pay the following: $2,100 as a fine pursuant to case law, $105 as the 5% surcharge required. I think, Marie, I think they still can. I think they still can because, like, he's using ineffective counsel. Like, I'm sure I haven't got to that part yet, but I'm pretty sure he's using that. $20 as a court cost pursuant to Crime Stopper Trust Fund, $3 to Crime Justice Trust Fund. This is all the money he had to pay. So we'll just go past all that. The defendant should follow the instruction sheet provided by the clerk concerning the payment plans. Okay. So that's all payment plans. Supplement directions to the clerk. The defendant, Charles Adelson, by and through undersigned counsel, directs the clerk to prepare an original and 2 copies of supplement record on appeal containing the amended judgment rendered on June 14, 2024. The clerk is directed to file the original supplement record on appeal by August 14, 2024. Marie says he had no witnesses in his case. He will stick with same story. He would have to. True says he paid all this in December. It totaled over $3,000 if I remember correctly. Yeah, I think that's what it said there. Armand, he is claiming that, also claiming he wanted to call Donna as a witness, but Rash was conflicted. Charlie has to sleep with one eye open in Florida. I said he has not left Leon County. I said it. Everybody's like, no. You're lying. You circus freak. You're lying. You're giving out misinformation. Knew he didn't. He was transferred to a Florida jail. And just recently, the clerk is directed to file the original supplement record on appeal. Oh, better get that off there because there's addresses and YouTube will freak out. Certificate of service with addresses. Direct Court of Appeal, 1st District. By order of the court, the court grants appellant motion filed on July 19, 2024, seeking to supplement the record on appeal with a copy of the amended judgment rendered on June 14th. Counsel for movement shall ensure preparation and transmittal of the supplemental record by the clerk of the lower tribunal on or before August 14, 2024. The court extends time for service of the initial brief to 5 days, blah, blah, blah. Where is his appeal? What is he saying? I, Gwen Marshall, clerk of Leon County, Florida, do hereby certify that the foregoing pages of the inclusive contains the record, Charlie Adelson, Corley versus State of Florida, of all such papers and proceedings as said cause. Okay. That's it. What? It didn't say anything about what? It doesn't give us a breakdown what his appeal is. That's 12 pages of, that's as much as the friggin' waivers. Hold on, let me just check here, guys, and see if there's something else that I'm missing. That's 12 pages of nothing. Appeal record E filed to DCA. But there's nothing there. Are you kidding me? What about all the tape phone calls with Charlie and Donna Race? So I'm going to have to figure out how to do a FOIA for that tomorrow, because they're not just giving it to us. Maybe it was because Rashi got into trouble, planned so Charlie could claim Rashi was a bad lawyer and he didn't give him a good defense. I can't even, but I can't even with these people anymore. There's just too much. So that doesn't give us anything. So I'm going to have to try to find out how to get his actual appeal from DCA. Armand, can you do me did STS have the whole appeal? Let's see if STS had the whole appeal. Yes, Tim Jansen did an analysis. All right, perfect. Let's just go over there. Let's just go over there. Oh, he's live right now still. Let's see. Okay, so he must have did it early on because they're talking about P. Diddy right now. So we'll just go and listen to. I'm just getting. Okay, we're just going to go on here. Let me put him on in one sec because I've got to present a share screen. One sec, guys. I've got to do this. I'm going to add myself here. Go like this. Sorry, because I have to make sure. No, I don't want to be big like that. There we go. I have to put up a banner First, I forgot to run my ticker because I have to hide their chat. That's not going to be a big enough banter. What if I make him smaller? What if I make him smaller? No, that's not going to work either. I love your coffee picture. So pretty. Thank you. Just trying to figure out how to do this so their chat's not showing. But that's too small. Well, that's going to have to be good enough. I don't know if I can add another banner or not. Oh, no. It won't only let me do one. Hey, tennis girl. Hey, thank you at Crime and Coffee Crew and awesome chatters. Okay. Let's just see. I'm sure Joel's going to strike me, but I'm sure he will strike me, but oh well. Let them. I'll take it down.
It's Wednesday. An appeal was filed. I literally have not looked at it, but I know you have. So I just wanted to bring you in, and you'll take questions. And I think tomorrow night we will do a proper show. Tim, what do you know?
So this is not the appeal, okay?
Okay.
What?
Oh, okay. Because Joel doesn't like when he's doing a live anybody to review him. And he doesn't like it till I think it's like a couple weeks after. Then he doesn't mind. So, but I'm interested in this. Oh, so it's not the appeal yet. Okay.
What they file is a motion for the appellate court to relinquish jurisdiction because they believe there's an evidentiary hearing that needs to be done, and it's economically should be done with the appellate court. And it came to the attention when the conflict arose with Dan representing Charlie, right? Well, now we know it's coming full circle. If you recall back then, remember when Donna and Harvey was on the witness list, and then Georgia wanted to depose them, and the lawyer came down there, said they were going to invoke the Fifth, and Georgia was going to give them immunity, a subpoena. So then Dan took them off the witness list, meaning that Charlie did not have the ability to have a crucial witness at his trial because there was a conflict of interest and a divided loyalty between Dan, Donna, and Charlie. Dan said he released her because he was protecting Donna.
I told you that bombshell Charlie threw. I knew that bombshell that he threw was coming back on this one. I am so angry about this. It lived up to the world bombshell for sure. Yep, that bombshell Charlie threw at Donna's trial. I said it was going to, and there it is. He waited for the right moment to throw it. This whole, I don't know, guys. I don't know what lawyer they got advice from the beginning, but I bet you somebody from the very beginning says use rash bomb. because you're all going to be able to use this. Because it made no sense to me why Rashbaum was the lawyer. He's a finance lawyer. And there it is. There is the reason they used Rashbaum. Yeah, what a mess. Oh, just that one sentence has set me off. Oh, tennis girl, I feel it. I'm set off just like you. Yep. Mary says, can you explain, Rochelle? I'm confused. So Donna and Harvey were clients of Rashbaum. Then they supposedly signed, I'm going to say supposedly now, signed a waiver so Charlie could be represented by Rashbaum for the murder trial. Charlie uses Rashbaum. Oh, all right. Tim explained it pretty good on STS. Let's just listen to Tim. He's a lawyer. I'm not.
Which may be true. But at the same time, he harmed Charlie's ability to call a witness who could have corroborated his conspiracy story. So they're saying not only he couldn't represent Donna, but that his reputation of Charlie was a clear conflict, and that he suffered because he couldn't call Donna a witness. And that's clearly a conflict because she's a co-conspirator. You can't represent two co-conspirators in the same case because you can't call them.
Fucker.
This is your evening to ask Tim whatever you would like about the Adelson trial. And so, Tim, by the way, if there's ever a night to buy the mods a coffee here, this is the link. They're the hardest working mods in true crime. And please, if you can, reward them with a coffee. They deserve it, and then some. And Space Coast on the West Coast.
I'm glad STS said that because I was gonna put it in. So the buy me a coffee thing on my channel is now for the mods. I think I put it in the description on this show, but I'm not too sure if I did. But it's now for the mods. And anything that goes in there I will be sending. That's why I wanted all the mods emails. That way I can send out like a Starbucks gift card to the mods.
Goes out here. I think he's watching the Mets Dodgers game. What do we have a score, Spacey? Put it in the chat. And thank you all for being here. And I would be lying if I told you I wasn't a little exhausted at this point, but we're all good. So Tim, once again, so this is not the appeal.
No,
this is a request for an evidentiary hearing. Are we going to get an appeal, or is this the process? First then that?
Right. This is saying judicial economy. Before we go through the whole appellate process, let's have the court relinquish jurisdiction and resolve this matter. Because if he didn't get a fair trial, and the case law is pretty clear on this, that he had a conflict. He represented Donna before he represented Charlie, if you recall. He represented Donna and Harvey before he represented Charlie. And then he listed Donna as a witness and didn't call her because of divided loyalty. That's clear conflict. That is a 100% conflict. I think Judge Everett's going to see that was a conflict. And you'll notice in the motion, he contacted the attorney representing the state of Florida. And they didn't say, we object. They said, we'll have to get back to you, because they know this is an issue. They know there's some substance here. There's meat on this bone, have you? And it's a problem. This lawyer.
Deb says, I don't do Starbucks, none around us. Then whatever you do, Deb, you just let me know.
Tried to represent too many people. He should have been conflicted off and not represented anybody. You just can't represent multiple defendants in a conspiracy. And he did this. And now he's tainted every trial. I mean, at least Donna and Charlie's, because he was too close to his family. He didn't abide by the rules. He got kicked off one case, got another lawyer kicked off, and now Charlie's conviction is up for review.
This is simply amazing. So, Tim, there was a source close to the appellate team that I spoke to who said that there was going to be some kind of quote unquote bombshell in the appeal. You're now telling us this isn't the appeal. I cautioned everyone. I mean, I pretty much cautioned everyone. I don't really, is there a bombshell here? I don't think that there is. What do you see?
I think this is a bombshell.
Yeah.
Not only is he saying we can't even do the appeal yet, Judge, this trial was so tainted and is so unjust. You have to grant a new trial, and you have to have the court do a full hearing to determine if Charlie got a fair trial when his lawyer was conflicted. And I think that they have a good case here. He represented Donna and Harvey. Then he represented Charlie. He listed Donna as a witness and Harvey. And then when the state was going to call them, he, on his own, withdrew them as witnesses. So the defendant, the co-conspirator Charlie, was unable to call two crucial witnesses in his defense because the lawyer had a conflict. And there's case law that he's probably going to get a new trial.
Tutti Frutti.
Guys, I can't. I said this. Rochelle, NFW. Rochelle doesn't understand some of these things, JJ, but welcome. NFW. Oh, no fucking way. Is that what NFW is? I'm going to say it because right now it needs to be said. Oh my God. Oh. So basically it says Charlie didn't get fair trial because he couldn't have his own witness. Donna could have corroborated his story out. Oh, Rashi wants the cash. Oh my God. I can't. You've got that, Armand. Gives Charlie Smirk a whole new meaning. He knew what the hell he was playing at right from the beginning. I wonder if there's a little bit more with this David Oscar Marcus than we've thought to believe. I think this whole thing was manipulated by Charlie and Donna. Honestly, guys, I don't know if Donna manipulated this one. I'm not going to take away that from her because it's a good possibility. I think Charlie had some friends in high places and he knew what he was playing at. Charlie never met Ufferman until he arrived back in Tally. Yeah, this is not, I think this is pre-trial. I think this is pretty darn close to the David Oscar Marcus time. And does anyone think the state will do anything? I don't. They are going to stay many steps behind the criminals. Yep. Yes, they are. I agree with you, Tennis Girl. Hey, all. There's 37 watching and 22 likes. Please hit that like button. Yep. Top Cat, we need to rewatch the hearing where Rash takes D and H off the witness list to see if Charlie waived. That was one of the early. Anybody that's quick on it, if you can find that link, we will rewatch it. I think the money bought an intelligent attorney and he figured it out. David Oscar Marcus. I asked this question to Carl in his live when September 16th bombshell about meeting with appellate attorney. Oh my God. Yes, I agree. I agree. Rashi probably did not get a written waiver from Donna. Probably not. You think it was Charlie? I don't see Rashi trying to plan this because this is going to go against him legally. What about all the tape phone calls with Charlie? Praised. Yep. I don't know if that'll work against him or not. Marcus is so much more famous than Rashi. Stepping aside means this was planned. And I almost, oh, this is sick. One step at a time there, state. One step at a time. One conviction at a time. You might as well pretend you're fucking Eeyore from Winnie the Pooh. Unbelievable. I hope someone finds a way to file suit against Rashi's firm. Malpractice insurance, that would get him good. Wow, guys. Poor Eeyore. What are they going to do now? What is the state attorney's office going to do now? One at a time again? Now they're going to start with Donna? Then get Charlie? Round them up. Round them up. Arrest them all. Let's be done with this. I agree, Tennis. I agree with you because that's the way they're playing this. Oh, I am so angry, guys. I will get back. This is why Rashi was so concerned about the Bar Inc. convo with Georgia Hot Mike. Yep, because he knew what was... Yeah. Y'all think Jack Campbell going to do another presser? No, but it gives more light to that presser, doesn't it? It's almost like he knew. That's why he was trying to say there's so many other cases and this and that. Fucking guy. Fucking guy. That's all I gotta say. This is an absolute disgrace. The Markells deserve better than this. I'm appalled. B-Rabbit. What if they tried Charlie and Donna together now? They won't do. They won't do it. They're too fucking scared. They're too fucking scared after Sigfredo and Katie. Put them all in jail. This is ridiculous. Marie says, I think any evidence they have can still be used. I think in end, Charlie will be convicted again. If he gets another trial, still in jail till trial again. Absolutely, he's still in jail. But the fact is, they won't go after another Adelson until one's been convicted. Now, if they've got a retrial to do, Tim says they can't try them together later in this. No one saw this coming, and anyone who claims they did should have shared their supposed wisdom with Georgia before Charlie's trial, but no one did because no one saw it coming. The fact is, for me, was he represented Donna and Harvey prior to Charlie. It should have been a no-go in the first place, but trying them together isn't a good idea, in my opinion. Look at Young Thug trial, yikes. But true, but one of them would flip, and one of them would be Charlie. He would be the one to flip on everyone, especially now. Especially now. Biggest setup. True that at True Crime Wifey and Tim J said it would cause a problem with one of testifying or something like that. Like they should have just done it in the first place. And that's exactly it. That's what it was said, was because even Wendy said it on the stand. Because the state wouldn't call them and give them the same immunity as she got, they would have to be called for the defense. And then the defense said they were going to take the fifth. I don't see it being a rashy manipulation, because he would instantly be thinking about his bar license. I just don't see this. I think they manipulated Rashi into taking the case for Charlie. And he didn't think anything because he saw too many Benjamins. Yep, no wonder Wendy has been free all these years. And now she's getting more time. Oh, Elizabeth, I can't wait for Carl's reaction. I cannot wait. Rashi's not smart enough for this. All Offerman. Oh, you think it's Offerman? Okay, this game plan right now, Offerman, but I think it was pre-set up by a smarter attorney that talked Charlie. Got Charlie, because, I don't see why he would go from David Oscar Marcus to Rashbaum. If Charlie gets convicted again, I think he will flip on Wendy at the point, nothing to lose. Donna will probably be convicted at that point. Could take a year, almost 2 years for Donna to get to trial. There's a very real chance that Miss Ruth and Mr. Phil will never see justice served. And that's what Phil said a couple weeks back. Phil said it himself, guys. A retrial hasn't been granted yet, so let's all pray Rashi got a waiver. Someone in STS chat said they remember Charlie signing something. Donna and Harvey orchestrated this through Wendy's advice, in my opinion. Yeah, Offerman is excellent. Offerman is also Crazy Wade Wilson's appellate lawyer. Perhaps the court will find that Rashi was representing Donna on civil cases and not on this case, so no conflict. And I think he was representing her for this case when the indictment came down, right? He started representing Donna in 2016 when Katie was arrested. Yes, at B Rabbit, that's the most heartbreaking thing. As mad as I am, I'm certainly not in their situation. I think that's what makes me the maddest, is that this family isn't getting justice. Yep. He's representing Wade Wilson. All the Wade Wilson wives that have donated is paying for Offerman. So the best scenario would be Charlie gets a new trial and is found guilty. Yeah, he'll definitely be found guilty. But oh, sorry, Patricia. I didn't just seen you come in. Welcome. Oh my God, guys. All right, let's listen to more Tim here.
Here, bottom line, Tim, is Chuck getting a new trial. What do you think?
He might. If you look at the opinion, what Everett ruled in Donna's case, it was clear there was a conflict. It was clear there was not a waiver. It's clear that it's one of those conflicts that can't be waived because they can always change their mind. This one can't be waived because did anybody in the trial ask Charlie, are you waiving the calling of Donna and Harvey because of a conflict that your lawyer represented them? I don't think that ever came up. I don't think there was a waiver by him. I think when he spoke to his appellate lawyer, Mr. Offerman, who's very smart, and Laura, who works with him, very smart, they saw this conflict and they saw how it circles, it goes back.
Where's the justice for Dan Markel? There is no justice. Let's just be honest, guys. Let's just be honest with ourselves and honest out there. There is no justice. This is insanity. 10 years. 10 years. And nobody, even when Charlie had Rashbaum, there's nobody brought up, knowing that the mother and the father were unindicted co-conspirators, brought up this big issue that might be an appellate issue. Not one of those goddamn lawyers did what they should have done. And I'm sorry, Georgia, and I'm sorry, Sarah Catherine Dugan, and I'm sorry, Jack Campbell, but what the fuck are you guys being paid for? This is disgusting. I'm angry. I'm angry. I knew there was something fishy going on when I saw that press conference. Yeah. Putting the Markells through a lifelong nightmare just shows how evil this whole family is. They do have more new evidence against Charlie, so that's something. I think you can put link to STS show in your description and might not get a strike. I will do that. I'll do anything. I'm even going to put a banner up. Thank you, Joel. Anything I can do. This was their plan. And by the way, apparently this is not an appeal. This is a motion to bypass and change something and just grant him a new trial. Tim explains this also. Which is even worse. Tennis girl, which is even worse. Very elementary. Yep. Charlie can say Wendy was working with him, with the hitman on WhatsApp, and that's how they knew the car, the location, etc., and went to the crime scene. This is disgusting. Patricia, I'll get started on a rashy one ASAP. You're so good at that, Patricia. I would love to have a book of yours. So you think you can do better than mine? I know you can. Yep. Yeah, it's even worse. An appeal would take longer. This is their pass site trying to bypass the whole appeal. Yep, it's a change of jurisdiction. And all the damn bitch had to do was tell the truth. Oh, God. Oh, my God. I cannot believe this is happening. I cannot believe this is happening. 1 second, guys. I have to do something. I have to do something. Give me 1 sec. There. I'm putting up a new banner. I need to put up a new banner. Oh. None of them are flipping, in my opinion, all going for outright acquittal. Good chance, Top. Good chance. This is the most out of control family I've encountered. It's worse than fiction. These lawyers are going to call us all keyboard warriors for not understanding the details of the law. Piss off, you shady attorneys. Yeah, this is fucking disgusting. Jane, if Charlie does that, he is admitting his guilt unless he says that well-hired hit and she did all the with Katie. But again, Marie, he knows that he's looking at life without parole. If he goes out and flips, and there's a good chance it won't happen, but if he did, because he knows what he's in for, He might get a juicy sentence. He might get a good sentence. He'll still get a sentence. He can't win in a new trial, so he's up to something else, a plea or some new story. Yep, I agree. No appeals for Sigfredo Luis or Katie Adelson's, especially Wendy getting last laugh, in my opinion, won't happen, though. This is disgusting. And all the while, CA is in protective custody. What a coward. Yep. Agreed, Top Cat not happening. And when you see how state is always several steps behind, why would they? They can always come up with something. Yep. What's the chance Harvey and Donna get their Vietnam villa back? Oh my God, guys. Oh my God. I can't even.
Back to his original case. And maybe this is why he decided he wasn't going to testify. He knew this motion was going to be coming. And maybe why he was kept here for so much longer, hoping that they have a hearing, he would be available to testify. And he'll probably testify at the hearing that he wanted to call his mom, that I wanted to call them. And Daniel told me not to do it. And because he had a conflict.
And how soon could this evidentiary hearing be held, and who's it held in front of? It's obviously not Everett.
No, it will go to Everett.
Oh, it
So
does.
They're
Okay.
asking the appellate court to relinquish their jurisdiction because they have it now. You have a conviction.
Okay.
They're asking him to send this case back to the trial judge.
Wow.
And let's have a hearing before Judge Everett. And let's call these people in. Let's call these witnesses. We're going to call in Donna. We're going to call in Harvey. We're going to call in Daniel's going to have to testify at this hearing. Why he released Donna from being a witness for Charlie. It's not going to go well. I think the appellate court probably will grant and let the court do an evidentiary hearing. It's a disaster. It's a disaster.
How long does, thank you for clarifying that. This is, I guess, it is a bombshell, I guess.
Jane says there once was a lawyer named Rash who never could get enough cash. He kissed up to Donna. Now Charlie's who's getting drunk on toilet mash. Oh. That is that is awesome. That is awesome. What a night.
Tim, how long before the evidentiary hearing, how long is an evidentiary hearing?
Oh, this hearing, I mean, you can have evidentiary hearings that take 2 days, 3 days.
Oh, good.
The state of Florida is going to have to respond, right? And they're eventually going to have to, would it be surprised if they say, we don't object, we think an evidentiary hearing should be held? They have to really take a soul search and look at this and figure it out that so many people miss this conflict. And the judge already ruled there was a conflict because that's why he kicked him off Charlie's case. So if he ruled, that ruling would apply also to Charlie's case because he represented Donna. Now, if they didn't list Donna as a witness, right, as a category A witness, it might not be as good because he said, well, I would have. No, they had them listed as witnesses. And the information is going to be, why did they withdraw them as witnesses? Was it because they were protecting Donna? That's what I think the allegation is in the motion. If that's true, then you have divided loyalty. You got one lawyer protecting one defendant and not the other witness. And that's a conflict. And that means he didn't get fair representation. He didn't get a fair trial. Now it may go back that they don't grant it, right? And then they come back after the appeal and argue ineffective counsel. And that would clearly show that he couldn't call a witness because the lawyer had a conflict. But I think Ufferman, Mike, and Laurel did the right thing. Let's clean this up right now. Let's look at it before we file an appeal. And the appellate court's like, hey, why should we do the appeal? If this might be a new trial anyway, let's just resolve that before we have to do any more work. Let the trial court figure it out. and maybe they'll give him, and we don't have to do anything.
Jesus Christ. Could Donna have hired Rashi knowing what Charlie was planning to do? She could have, but her own words and the way how devastated she was in court that day, I don't believe she knew anything about this. I don't believe she knew her son was going to throw that grenade. I truly don't. She was devastated, and in her correspondence with me, she clearly did not know that was coming. Did he say Offerman is in the same office as Laurel? I will go back. Oh no, the other attorney. So there's Offerman, and I think it's Laura are the appellate attorneys for Charlie. True says, I thought I'd never say this, but Tim's right. The District Court of Appeals is going to bounce this back to the trial court. Oh, mother of God. So Donna thought she was going to be acquitted. She thought she was going to get acquitted. Yeah, no, not Wendy's Laurel. Not Wendy's Laurel. Yeah, she thought, guys, you remember, what's this? Oh, hold on one sec. What's going on here? Jane said something, but for some reason it's not coming through. It says, please excuse my French, but F this. Yeah. Sorry, YouTube tried to stop you, but it didn't come through into StreamYard, so I got it over there. Oh. Patricia says, there once was a lawyer named Rash whose criminal defending was trash. He ripped off his client with an ease of defiant, but now his career is a big ball of ash. Nice. Nice. No, yeah, we're sure it's not Wendy's. Let me pull it back up because it says her name in the docket, in the thing. I'll pull it back up and get her name for everybody. Give me one sec. This just blows my bloody mind. Let me just pull it up again and I'll grab her name for you guys. Pardon me. I think it's Laura who had the long hair. Yeah, I'm just going to grab her name here. Yeah, it's Laura. Yeah, it's Laura. Let me get out of here. Back to here. Yeah. I know it sounded like when Tim said it, Laurel, but it's Laura. No, he won't be. If his conviction's overturned but he's just going to have a retrial. But if it was completely overturned, yeah, but he'll have to have a retrial. They'll have to retry him. Oh my God, that's disgusting. That is just disgusting. What a day.
That makes a lot of sense.
It does.
But by the way, there's big news today, and that is Charlie was moved out of the Leon County Jail and is now in the custody of the Florida Department of Corrections. Tim, I don't think we know which prison yet, but is there something to be read into this? Are they now keeping him here instead of South Dakota because this evidentiary hearing could happen soon?
I don't think that Michael Offerman would have alerted the court I think he's a very professional lawyer. I don't think that he would have told him, hey, keep him here. We might have a hearing. I don't think that the state attorney was, because they said they have to get back to him. So I don't even think Michael told the prosecution what they were doing.
No, but like Rochelle said, there was a good chance Charlie was going to be hanging around in Leon County until after October 15th, because that was when they were supposed to have that hearing for Donna. Didn't happen. But when the trolls come out and say, Rochelle, or they say, circus freak, you are giving out misinformation, Charlie's not in Leon County. Charlie was still in Leon County, just like I said. There once was a dentist named Harvey who thought killing his in-law was Marvy. His patients were drilled while his in-law was, and the shooters got a brand new RV. Patricia, it would be. Did you see my above message, Rochelle? Carl thinks it would be overturned. Yeah, but then he'd get a retrial. Just trying to find your above message, Deb. Carl has a show tonight at 10 titled Charlie Adelson's Conviction Will Be Overturned. He capitalized the will part. Oh my God, Carl. Oh, it's on right now. Carl's on right now. Oh gosh. Well, guys, I recommend we all watch Carl. I won't do that to Carl. I won't do his live while he's doing his live. That would be the worst possible outcome. I wonder if they will be able to use his prior testimony. I have no idea. Okay, guys, I think we'll end this live, and then, because I won't do that to Carl. Carl's been very generous to me, saying that I can stream his, thanks Rochelle, yours, stream his shows. He's too arrogant and militant. Oh, but I just don't want to stream his live while he's streaming a live. I think that's just, even though I just did it to STS. Oh, would Carl be mad at me? I don't know if Carl, I don't think he would be mad at me. I don't think Carl would be mad at me. He hasn't started yet. I'm watching his live, I think, Joel, on Court TV, so I'm going to watch that. I appreciate you, Tennis Girl. I appreciate you. Oh, what is going on? One sec, guys. There's some weird noises in my backyard. Helicopter flying over with the spotlight. Hold on. One sec, guys. And that's what you call a panic attack. Ooh. And that's what you call an instant panic attack, people. I just went and made sure everything is locked. Holy, my heart just went a mile a minute. I gotta slow it down. Carl's always late. Carl's always late. Oh, yeah. Well, I'm on his. Hold on, let me refresh. Oh, yeah, still waiting for Carl. I've got it up. I got it up, Jane. It's okay. We get text to stay in if something is going on from local. Yeah, we don't get anything like that. Lock your doors and put dog in room with you. Do you have an object to cause blunt? Yes, I do. Yes, I do. And I'm actually, my office is in the room that I escaped from, the door that I was able to escape from. So I'm right by the door. So using other content helps their algorithm. I got a nice little thing from John Steinbeck the other day. So I appreciated that. What is Shiraz? Shiraz is over in Carl's. Yeah, and I can do anything stronger. Even a bat could get me in trouble. Oh. Ooh, my heart is still pounding. Yeah, I never have in my life. Yeah, I will link them. Oh yeah. I'm pretty sure, like, now that I'm coming out of that a little bit, I'm pretty sure my phone's not even here and I have heard it going off. Hold on. Now here we go again. Oh, Casey used content I sent her for her own. She used it without asking and never acknowledged it. Oh, that's not nice. I don't like doing that. I think Carl is still in New York City with his sweetie. May take a while. Hey, Carl's always late. Carl is always late. Okay, I can't honestly, guys, I've lost my mind because I can't even find my phone now. Is Jamie still on here?
Markel, FSU law
Here we go.
professor, father of 2 young boys, was in a custody dispute with the boys' mother. The professor was, and the kid's mother was Wendy Adelson, and Charlie Adelson, Wendy's brother, a oral surgeon, is convicted, and want to talk tonight about a motion that was filed to the appellate court by the attorney for Charlie Adelson, Mr. Ufferman. Ufferman is asking for, in his motion, for the appellate court to relinquish jurisdiction back to the trial court level. Reason being, the trial court needs to sort out this issue on whether Charlie was denied effective representation due to his lawyer, Daniel Rashbaum, was ethically conflicted and constitutionally conflicted, in essence, from representing Charlie. And if you have ineffective assistance of counsel due to a conflict, that's pretty much going to toss the case out. So this is something I've been harping on for a long time now, ever since I saw that Rashbaum was representing Donna after representing Charlie and doing, as we saw, not a very good job. Charlie got convicted, and then days later he's representing and continuing to represent Donna Adelson. As we know that Rashbaum also said that the representation of Donna extended all the way back to 2016. So he's been basically representing Donna since 2016, then represents her son Charlie during his murder trial. And he also had the issue of the on the witness list, Donna and Harvey, the parents of Charlie, being on the defense witness list. They were also on the state's witness list. So there was a issue with that at the trial court level for Charlie's trial less than a month before trial, where there was a deposition hearing scheduled at the FBI office in Miramar, Florida, and there was a deal worked out with the state attorney's office and with Charlie himself, Charlie's counsel, Rashbaum, but Charlie was never part of that. Apparently, he never got consent to have his parents not testify, and he also never had consent at other stages of the proceedings, according to this motion filing by the attorney Ufferman for Charlie. So it's a real hot mess. It looks so bad for the case that the prosecution otherwise did an excellent job presenting the facts, getting Charlie convicted on this in just a couple hours, slam dunk win. But if you have conflicted counsel representing Charlie, the case is going to get tossed on appeal. So I don't even think this case will make it to the appellate level. I think Judge Everett will actually do the same thing he did on Donna's case, which is find that Charlie had conflicted counsel as well. And if you think about it, the motion that was, the order that Judge Everett signed off on, banishing these 3 defense lawyers from further representing Donna Adelson, he in there stated it was unethical representation by Rashbaum. So if it's unethical, it's automatically going to be also a constitutional violation. So since Donna was conflicted on that, and we now have Charlie's conflict coming up, in essence, Charlie even has worse of a conflict because Donna was the first client for him. So this is something that was easily spotted when Rashbaum first appeared representing Donna. He should have been bounced from the courtroom immediately. This is so much a open and shut case of that conflict. So think about this now, that it's so egregious, open and shut conflict of such a magnitude that Charlie was readily denied a fair trial due to his lawyer failing to recuse himself. So what's happening now is, I believe, if the state attorney can stand up and basically say it with a straight face that this is no harm, I find that hard to believe, and I'll actually be pretty shocked if they say there was no conflict here. I think it's abundantly clear there was a conflict, and this is something you cannot purge and clear away and make it go away by a waiver of all the parties. It was so much a direct hamstringing of the defense of Charlie, that in essence, Charlie had a lawyer that was looking out for his mom's interests more than his. And that's in essence what a conflict is that the lawyer has divided loyalties from one client to another. And when you have multiple co-defendants in a criminal case, especially something as serious as murder, which it doesn't get any more serious than that, to have this lawyer bouncing between all these different co-defendants. Keep in mind, he also was representing Harvey, who should also have been arrested by now and convicted, the husband of Donna. And what you have here then is basically a lawyer that's who's he most loyal to? I mean, he called Donna a mother figure to him when he's interviewed on Survivor. And by the way, I got a copy of this motion thanks to Steve Cohen of Surviving the Survivor. He's their guest manager and among other things. So thanks to Steve Cohen for shooting John, my brother, a copy of the motion and appendix to that. And so I'm just going to pull up that motion and give you any of my thoughts on that. But like I say, this thing's open and shut. I really think that state attorney's office will not oppose the basic overturning of the conviction for Charlie, because it's so clear cut that that this offends all standards of justice. That's why when I said this back when Donna first appeared in court with Rashbaum, I said this would never be happening in any court that I have ever practiced in. I don't know any lawyer that would do something this reckless and disregarding of constitutional standards and also ethical standards, for that matter, for the states I'm licensed in. So I don't know how he got away with it, Rashbaum. The court didn't intervene. The state attorney's office didn't intervene. So, but here we are now, and this is what happens when you're sleeping the switch on a constitutional law issue that can get the case reversed. This is the only issue that could have gotten the case reversed on appeal. So it's not. I don't even think this is going to make it to the appellate courts. I think what will happen is the trial court will go ahead and make the same finding that Rashbaum was ethically conflicted from representing Charlie, and grant him a new trial. And so with a new trial granted, we're back at square one, just like Donna. So Charlie, all that witness testimony, all the stuff that Markells went through, all that, my estimation, is going to be tossed. And are they really going to have a hearing on this? Because if the trial court doesn't find that there was a conflict, I guarantee you the appellate courts will, such a magnitude that Charlie will be granted a new trial. So in this motion it's called motion to relinquish jurisdiction to the trial court. So basically that means that instead of this thing being at the trial appellate court stage, Offerman, the defense attorney, saying, can we just have this issue resolved as a fact finder, the trial court judge, give him an opportunity to right this wrong of having conflicted counsel. And in the backdrop, he talks about the fact that, how Charlie was brought on as a client to Rashbaum after he'd already represented Donna for a number of years. And then he even says that in italicized print where he's saying prior to the arrest of appellant Adelson. So in other words, his loyalty to Donna started way before it started to Charlie. And so that shows it even more so that well, who's he most loyal to? Well, maybe it's the person he represented the longest, which is Donna. And he said that basically Mr. Rashbaum previously represented a co-conspirator in the same or substantially related matter, and he had an actual conflict of interest during the court's representation of appellant Adelson. And then he goes on to talk about how Donna Adelson was listed as state witness, and for the state as well as for the defense. And Donna was not present as a witness during the appellant Adelson's trial because she was removed from the defense witness list days before the trials to begin, after the state had sought to interview her. And he says the undersigned counsel asserts that Donna Adelson's removal from the witness list was done in order to protect Donna Adelson's interests, i.e. not being interviewed by the state, and against appellate's interests, i.e. a witness that could have corroborated appellant Adelson's testimony was not called by Rashbaum. Hence, Rashbaum's representation of appellate Adelson, meaning Charlie, at trial after having previously represented Donna constituted an actual conflict of interest. So what you have is a perceived conflict of interest that can be just as bad and can be treated the same as an actual. But here he's saying there's an actual conflict of interest, which is readily apparent. And then he says, as explained by the 11th Circuit Court of Appeals in a case named Porter v. Singletary, the federal 3rd Circuit, 11th Circuit, from 1994. An attorney who cross-examined a former client inherently encounters divided loyalties. Given the recent finding by the trial court in Donna Adelson's case regarding the Mr. Rashbaum engaging in a conflicted representation falling short of the ethical obligations for members of the Florida bar, Appellant Adelson asserts the same principle applies to Mr. Rashbaum's representation of Appellant Adelson at trial. Because Attorney Rashbaum was operating under a conflict of interest based on duties owed to former client Donna Adelson, whose attorney-client relationship predated Appellant Adelson's. So, and then they go on to cite some supporting documentation. And in that, there's like 107 pages roughly of an appendix. And in that, it shows the whole court history. It shows a probable cause arrest affidavit for Charlie. It shows some of the other court documents, including transcripts, shows transcripts of the hearing when the judge got these attorneys bounced, and they actually included Judge Everett's order, which removed all three of the Adelson trial lawyers. So this is really the thing that you would expect a good appellate attorney to do. It's pretty much standard, nothing complex or hard to understand about this. This is basically the basic foundations of criminal law and constitutional law interwoven. And what we have here is it's really astounding that we could have this much work put in and all of it's going to go basically kicked to the curb. There's nothing that's going to happen here to sustain the conviction. And I think really the court will grant this motion to relinquish jurisdiction to Judge Everett, and Judge Everett's going to make a very similar ruling doing that for Donna's case. So Charlie's going to get a new trial. That's what my prediction is. And based on that, Charlie's going to wind up having to start all over with all new fresh counsel, just like Donna. So in other words, Rashbaum wasted all this time for Donna, 10 months for Donna, and Charlie, he represented him for what, almost a year and a half. And all that's for naught, all this time in jail spent, which, they're guilty. So that's, I guess, one good thing about it, about the only good thing. But to have justice denied like this and delayed for so long is really troubling and disturbing. And you just wonder.
Sorry, guys, just want to send out a great thank you, big thank you to Sky Troop for giving me a call. I appreciate you so much for that. Thank you so much.
Why so many people were asleep at the switch. But in the end, keep in mind, nobody's going to get out of jail. Charlie's not going to get out of jail by being granted a new trial. Same with Donna. Donna's not getting out of jail. Charlie actually will revert back from, and I understand he just got released back from Leon County Jail in the last day or two to apparently back to South Dakota, but he's going to be brought back as soon as this is resolved. Maybe he'll be brought back as a witness if there's going to be a hearing, but I'd just be really surprised if the state's going to try to fight this. I think it's that open and shut. But I see prosecutors do it all the time. They got a really bad situation. It looks very unjust from the standpoint of justice, not taking any sides. If you just call a spade, and you look at this as being like, is this really fair to have an attorney that convoluted and wrestling in the mud with all these conflicts, swirling around him, and he can't see out of the mud. He's got so much mud in his eyes with conflicts, he can't represent any of these Adelsons properly. So that's what I've been concerned about the last 10 months, 11 months, that this thing was just a hot mess, and Rashbaum was way over his head, and nobody gave him a lifeline or pulled him out of water and shook him up and said, get out of this courtroom. You have no business being here representing multiple murder defendants. So, so we have definitely a thing that I think, the one thing I do think about this motion to relinquish jurisdiction that really will speed up the process, because Judge Everett, he's going to be all over this. He's going to have a hearing really quick. This whole thing about granting him a new trial, I think will happen probably within a month or less. That's just my guess. I don't practice down there in Florida and in Tallahassee, especially. So I don't have any practice working this issue, but it's a very good thing, because if he would have let this stay in the appellate courts, this could have been clogged up in the court system for like up to another year before the appellate courts took a stab at it, and then I guarantee you they would have reversed it as well. So in any event, reversible error means that he can be retried. It doesn't mean that charges are dismissed. I know some people are saying, well, if the court finds reversible error was committed in this case, does that mean that Charlie gets to walk home free? No, that does not mean that at all. It just means that he's basically going to be granted a new trial. So he's going to come back to Leon County probably next month. Leon County will be back there in the same jail. So think about it. Charlie and his mom will be in the same jail for up to a year, year and a half till they both go to trial. So that begs the question: is the state attorney's office going to try to try these two cases together, or at least have them sync to same time, where they're not going to wait for one to be convicted for the other? So I really hope that they look at these as some cases they just need to charge the other Adelsons of Florida ASAP. And with that, you can try to have all these trials pinned together. As close together as possible. Some of them try together unless the judge busts it up and mandates separate trials. But in any case, it's really I'm glad at least the Band-Aid's being ripped off now, and we see what a disaster this is laying out before us. And it was so easily predictable. And it's just one of those deals, I think, that I don't know why the appellate counsel sat on this so long, why they couldn't have raised this earlier, but maybe they wanted to sit back and let this issue to see if Charlie would be called as a witness or not. Even if Charlie wasn't called as a witness, this issue would have came out on appeal eventually, I think. And but anyway, the fact that Donna had a ruling from Judge Everett saying that Rasham had committed an ethical violation. That is serious. If you commit an ethical violation in a murder case, and it has something to do with you, whether you ethically represented your client properly or not, that's like a huge badge of dishonor and shame as an attorney. So, in any event, sorry, I got a call from my uncle here. I had to turn off. Let me turn my sound off here. Sorry about that.
Oh, mother of God. Help me out. Help me out. Put your questions in. I will input them into Carl's chat.
And better yet, I'll just turn the phone off. Okay. So I'm going to go ahead and jump to questions now.
Oh, that was quick.
JKC, you're saying if Charlie gets a new trial, will he be offered a plea to testify, implicate Wendy? Well, there's a possibility he could always decide to do that. Once he gets conflict-free counsel, that's one of the things I've been saying all along. Was like, how can he ever talk to Charlie about, hey, do you want to roll over and cop a plea and flip on another Florida Adelson family member? Because without that, you're going down. You're going down. You're going to get life without parole. Your only chance of ever getting out, seeing the light of day out of your prison cell is going to be if you testify, like offer to testify and implicate. Truthfully, obviously, you're not going to ask a client to like manufacture testimony and lie about someone else just to get out of hot water like that. So in any event, he obviously knows stuff about Wendy. He could implicate Wendy as well as Harvey. So is he willing to do that to save his own neck? So that's what the issue is. But that conversation could have never taken place with Rashbaum because he had his loyalties, I believe, most likely tied to Donna, not Charlie. And that's why the courts, whether it's Judge Everett or Courts of Appeals, they're just going to bounce this thing. I said the other day when I saw another attorney on YouTube saying there's only a 10% chance this will have any traction in the appellate courts. I said at least the opposite, the inverse of that, 90% chance of a reversal of the convictions. And now I'm upping that to 100%. There's no doubt in my mind this thing's going to get tossed.
Oh, God.
And yeah, it is a total embarrassment. It's really crazy. Kitty Girl, you're asking if Charlie gets a new trial, how do you think he'll plead out and blame his mother now that he knows his extortion defense didn't work? I mean, that's a conversation I'd have with a client like that. If Charlie was in Texas and I was a new counsel representing him, I'd look at the history of the case. I'd look at what his previous representation was. I'd look at Rashbaum and think, wow, this guy never could even talk about offering up testimony against other co-defendants and unindicted co-conspirators and unnamed co-conspirators. Because think about it, Harvey's never been even mentioned at all in any court documents as a conspirator in any way, shape, or form. But we know he has also involvement with this. Besides Wendy, now we know she was listed as an unindicted co-conspirator and she should have been indicted many, many years ago. And so, yeah, Cheryl Crawford, I agree, this is a total embarrassment. And anyway, getting back to the Katie girl issue, though, yeah, he could blame his mother now. That's really the only way he's going to come out ahead is if he gets his mom. But really, he doesn't even have to testify against his mom. I think the real one that they've been afraid to go after is Wendy. This one at a time approach would be sped up, obviously, if he agrees to.
I'm sorry, guys. Ian is in Carl's chat, and he says Wendy's gray dress has gone to the dry cleaners.
Flip on Wendy. So it remains to be seen. If he's smart, obviously he'll agree to flip on everybody and everybody involved in this. But we'll see. I mean, he's going to have a free, clean slate. But the fact that he already testified to this ridiculous extortion defense, to answer your question, I mean, any attorney with half a brain would say this is not going to work. This is ridiculous. A jury obviously already had the same opinion. So you sitting there thinking you're going to go to trial. What's the point of going to trial again to have the same outcome? There's even more evidence against you now. Now that we've seen the text messages between you and your mom, talking about when Sigfredo Garcia, the trigger puller, got arrested, and you guys were talking about how this is a drug deal gone wrong with Dan Markel, when supposedly this was an extortion theory going on. So the state obviously dropped the ball on not having that evidence available to cross-examine Charlie on, but they finally got it. So in any event, this is basically what happens when you have people that are not aware of how constitutional conflict of interest issues can pan out in a criminal's law setting.
One of the subscribers bought the dress for me. It's on its way to me.
Andy, you're saying this is a colossal dumpster fire lying down on a ski slope. Any ideas why the state didn't call Harvey and Donna and Charlie's trial? They could have decided not to call them because they have immunity issues and protection. In the event they did decide to go after them later, that doesn't prevent you from prosecuting them. But I don't understand it, why they wouldn't have put that pressure on, at least done a deposition. I don't know why they wouldn't have done a deposition. So I don't understand a lot of stuff the state attorney's office is doing. It makes no sense to me. And in any event, I think the mere fact that they're both on states and defense witnesses is going to be a factor that the trial judge mentioned, and that's going to get this case bounced and a new trial granted. Yeah, I'm not going to rant like I have on some of the other evenings. It's just really one of these deals where you already know my opinions on who shares all the blame on this kind of thing. It's just really upsetting to see that, and it's just at least like I say, it's the Band-Aids being ripped off, and this thing's going to grant and start all over. So basically, it's the time that Charlie served in prison isn't going to count. His conviction isn't going to count, and he's going to get a new trial. At least I would think the state attorney's office is good to save some face, so it start charging the other Adelsons. But who knows? We'll see. Yeah, Kathy. This is one of the twists and turns. Yeah. So it's just really just one of these deals that just makes this saga, this case, keep going on and on, getting stranger and stranger, more twists and turns. And I mean, this is a story not only about the criminal defendants and their bumbled attempts to kill someone and get away with it, but it's almost like you look at all these other cast of characters and they get involved in the case, from Megs and on down the line. It's just like you can't have you couldn't make this stuff up in a movie, and no movie would find this stuff credible. People would be bored with it. Yeah, it doesn't happen in real life that way. This is too crazy a story. So. Okay, Sally, you're saying, didn't Harvey and Donna threaten to plead the fifth if the state called them as witnesses? Wouldn't that be in writing? And now Charlie is saying he couldn't call Donna because of conflicted counsel. Yeah, I mean, that's what through the counsel at the time, Marissa Descalzo, she was the one saying that they were going to invoke the fifth and they weren't going to cooperate. And then that fired up Judge Everett. And he was the one that basically said, no, they will cooperate. And if they don't, I'll have them arrested and brought up here to Tallahassee. So that's what, they were not able to plead the fifth and not cooperate. Descalzo didn't know about the fact that there's a criminal statute. Actually, it's a statute for, I believe, civil and criminal, where if they call you as a witness, if the state calls you as a witness in a proceeding, you're guaranteed immunity for the use and derivative use of whatever you say. So you could admit to murder. They can't charge you with murder based on your confession. They would have to have independent evidence, completely not being derived from your testimony or your actual testimony. So that's what that means. And so it's basically a Fifth Amendment right to remain silent, piercing statute. So yeah, but they could have called them in for a deposition, and both Harvey and Donna would have had to cooperate and testify. Otherwise, they could have been held in contempt of court if they didn't, and be in jail until they do cooperate. So, but yeah, that specific example of Charlie Rashomon deciding not to call Donna as a witness to preserve her interests. That's what was emphasized in italics in this motion, is that that's something that Rashomon had said, that he did this to protect Donna. And meanwhile, it's like Donna wasn't facing murder charges, but Charlie was. So your loyalty was to Charlie at that time. But since Donna was like a mom to him, he represented her for many years previous while she's awaiting to be arrested and indicted. That's why this whole thing is he's so wrapped around the axle on this conflict that it's just really so bizarre that it took this long for anyone to do something about it there. Collier saying, can the state try them together now? Yeah, I mean, they might as well let the court decide if they need to separate them, but try them and try all these other Adelsons at the same time or near the same time if you're not going to have a consolidated trial. So that's something I've been saying all along, and maybe they'll decide to do it now. And then it's like, look at how botched up this one at a time approach works when you have a conflicted counsel that played everybody like that. Yeah, Julia Nielsen, you're right. Both Charlie and Donna do need a new defense counsel, starting from scratch. They gotta start over. And so yeah, I think Rashomon, imagine what kind of trouble he's going to get. I don't know how tough the state of Florida is on a conflict issue like this, but he could be subject to sanctions, and I don't think he would be disbarred over something like this, but he could very well face some kind of trouble, like being suspended for a year or two, something like that. Have no idea. I'm just going by what would happen in other states that I practice.
Charlie going to go back for money on
have
him?
Licenses in. Yes, me, Brooke. Yeah, that's what you're saying. I'm just saying the same thing, that with the overturning of his conviction, the state can then have a joint trial, unless the judge severs it. If there's issues involving, they have defenses that are problematic. If you have them tried together, then that can cause a judge to sever it. But the whole issue remains: don't wait until the one is convicted actually before you go forward with the next Adelson. Line them up in a daisy chain effect, as we call it in the military, where you charge one month, and a month or two later you charge the next one, and you pretty much got to do a tight shot group for all these Adelsons, and that's the way you really force them all to be every man for himself. Yeah, Maya Rodriguez Sorensen, also a lawyer, saying Rashomon made it seem like he was more protecting Wendy than representing Charlie. I mean, he was really going after this long scripted questioning for Wendy. I agree with you on that. And it looks like he was trying to make it look like she had nothing to be involved in this case, and was just, it looked like it was so rehearsed between Rashomon and Laurel to have Wendy know the questions in advance. She acted totally different when being questioned by the state versus being questioned by Rashomon. And Rashomon did look like, this was a client of his that was coached. So because I think Donna probably wanted Wendy protected more than anybody, yeah, so you could say that as well, that it looked like he was protecting Wendy more. That wasn't raised in this initial motion. for the court. But yeah, that's definitely something that that I would say could be raised as well with if it needs to be further developed on the record. Saeed Barbie, I agree with you. Rashbaum should have never been involved in any of these Adelson cases. Spiritual chick, I don't think that this has been planned all along. You think they had an end game? I don't think a lawyer would intentionally throw
I agree.
his license on the line to help somebody that he says is like a family member, like a mom. I find it hard to believe that he really thinks she's like a mom. Look how quick he dumped her. And I guess in the hallway elevator, he said that he's going to be glad to get away from this case. So he's not going to be talking to Donna anymore. So he's moved on, and Donna's left alone holding the bag. Nurturing 2, you're asking, will Rashbaum receive any sanction or other actions from the ABA? That's the American Bar Association. I'm curious how this will impact him professionally. This is a mess. Poor Markells. So this will, not the ABA, the American Bar Association doesn't have any disciplinary authority over any attorneys in the United States. What happens is we're licensed by individual states. So the individual states, they're the ones that have the responsibility for addressing and having hearings and findings and recommendations to the Supreme Court on how attorneys' licenses should be handled. So, and if you're licensed in multiple states, if you're found to be sanctioned in one state, let's say you're disbarred in one state, if you're licensed in a second state, then that second state would also find you disbarred as well for the same amount of period. Okay, Sally A., you're saying, do I believe Charlie has been wrongfully convicted? If he has a retrial, he is going to be found guilty again. Yes, he is going to be found guilty again on a retrial. So in essence, this is just burning up more Adelson money. So he can find a $10 million lawyer team. That's not going to help him escape another conviction. So I guess that's the one good thing about it. But, evidence can decompose over time. Witnesses cannot be available. So that's why they really need to start moving out on this case and just get over this Adelson murder case once and for all, and have the proper foresight to see that this wanted.
Armand says, I recall a jailhouse call. Charlie said he had no chance at appeal. Perhaps he did not know the implications of a conflict. Rash should have known, though. Or did he know and realized his mom would use Rashi too, and he kept that bombshell to himself? Something's telling me he knew this was going to happen way, way in advance.
The time approach is just not working. If they would have had this all at the same time, Rashbaum would not have represented two Adelsons at the same time, because he would have recognized it too much to handle at one time, and I think it would have made more people realize, wait, you're representing two murder co-defendants in the same trial? That's even more bizarre than having it one at a time like this. So I think that would have piqued enough interest that he would have been shot down. And so in the end, this one at a time is coming back to really bite him. Now, if this gets some kind of traction where Charlie's saying, I'm tired of this. I've wasted all this money. I just want to get out as fast as I can. And with his new attorney, he agrees to flip on more Adelsons. Then I guess in the end, that's a benefit from this happening. But anyway, there's going to be twists and turns, and we don't know exactly what's going to happen. But if he's got good defense counsel, they could probably talk him into that. Thunder Queen, you're asking, is there a hearing where Rashbaum will be called? Yeah, all these parties could be called. I don't think Judge Everett really needs to get much into that, though, because if I was Rashbaum, I wouldn't want to be anywhere near that courtroom again. Keep in mind, he's from the Miami area. So if he gets called as a witness, he's going to explain this stuff. And it's just so embarrassing.
Oh, this is
the worse he looks on the witness stand, the more it's going to look worse on the judge and other parties. So I really hope the state does the right thing and basically agree that, there's a conflict of interest there. And I guess if they want to remain silent on the recommendation of the court to whether to grant a new trial or not, the judge brought out their opinion on that, though, as well. So in essence, I do believe that Charlie was wrongfully convicted on a technical issue, but a constitutional issue at that, having to do with his lawyer could not properly represent him. He was ineffective per se. And if you're ineffective per se, that's a constitutional right to having effective counsel. So I think the case will be probably.
Top says at 10-minute mark, if anyone looks it up. I got to get the link to that, and then I will look it up. Top. I think Charlie's appellate lawyer brought it to Charlie's attention, but he hasn't really even talked to Charlie that much. First time I'm not sure if it's the first time he actually spoke to Charlie when Charlie came to Tallahassee, or the first time he saw him when Charlie came to Tallahassee for the trial. Jeez, Carl's
Be
making
resolved, like say, within a month, and then you'll have to start over. Yeah, I don't know. No, I'm not saying he's going to be a witness, but it's potentially he could be. Rashbaum, that is.
Oh, he's going to be a witness. There's no doubt in that.
Okay, Carrie, you're saying can they use Charlie's testimony against him if he's given a new trial? They could. They're not going to. They're not going to use that, what Charlie said in his first trial and against him in the second trial. They're probably going to let that be there only for impeachment purposes. So in any event, his testimony is so ludicrous and so outlandish that they don't let Charlie present some kind of defense and whatnot. But I just don't see another lawyer being like Rashbaum and thinking that something that ridiculous is gonna carry any weight with a jury. So if I had a client that was being that foolish and not gonna cut a deal, I would just tell him I'm not gonna handle your case and prop up some kind of garbage defense like this and look like an idiot myself. Sorry.
Say it like it is, Carl.
Yeah, Dog Mom 54. The court should have stopped Charlie's trial before this even happened. They were wasting the court's time. Yep, this should have never gone to trial. Charlie should have gone to trial with Rashbaum. CC, you're saying even a new trial won't take his guilt away. What are your thoughts? Well, yeah, I mean, under the law, he's innocent until proven guilty, right? So what we're looking at, those evidence. Florida has those liberal laws allowing us to open back the see all the video and different police documents and whatnot. So in the end, he will be convicted again. So that's really all that matters, is that there will be a follow-up conviction. Inky Pinky, you're saying, well, Charlie need to find a new lawyer as well. That's what I'm saying. Even though he said Rashbaum was wonderful, clients don't understand the ethical conflict. I mean, it can sound very complex, convoluted, but it's really not for attorneys that practice in criminal law, where, like I say, the constitutional aspects of conflicts are raised and run from by attorneys, unless it's Rashbaum. Then he ran directly into this basically hurricane of a legal disaster quagmire. Whitney Marie, you're asking, how did Rashbaum remove Donna and Harvey from the witness list if they were witnesses for the prosecution, since they were getting immunity? I think what happened was, Rashbaum wasn't representing at that time. When they got subpoenaed witnesses, then I think they ran out and grabbed that Descalzo female attorney down there in Miami, and she doesn't practice criminal law, so she was resisting that and telling the prosecution that they had no authority to depose either Harvey or Donna. And what happened then was that this issue came out where, they're both on, the prosecution has a right to call them for a deposition because they were listed on the defense witness list. And Rashbaum said, okay, they're off my witness list. And can we just decide not to call them at all? You guys not call them at all, because we won't. If we promise not to call them, then you won't promise not to call them as well. So we'll sort of make them go away. And that's what I recall the agreement was between the parties. And so with that being the case, Rashbaum wasn't representing Donna, but he obviously said that he had loyalties to her. And that's what this motion's saying today, that he's basically did that to protect Donna instead of using Donna to corroborate think about it, Donna was the only witness to corroborate this whole concocted story about the this double extortion that is really a farcical robbery on a payment plan. So anyway, Donna was the best witness and only witness to corroborate that, because keep in mind, they said they never told any of the other family members, or at least Charlie said he never told any other family member, including his dad and Wendy. And remember, Wendy said she just found out about the fact that Charlie knew who the hitmen were from day one. So this whole thing is just so corny. You can't believe it. None of their stories made any sense. None of it was credible.
That is true.
Yeah, so Sally, Rashbaum was representing Dunn and Harvey as a criminal lawyer, as a suspect lawyer. So when they were finding out that the hitman got arrested, they right away hired their own lawyers, and both of them went to Rashbaum, hired him to represent both of them. And if you remember, there was a joint statement given out by Rashbaum, John Laurel, which was Wendy's attorney, and also the David Oscar Marcus.
That is very true, Armand. In the new trial, his email about Dan's drug deal, yeah, that will come in. Absolutely. Adelson's choice of attorneys tell me they are more worried about their money misdeeds than they are about murder conviction. It's weird. What are they hiding financially? I've been saying that from the beginning with Rashbaum. From the very beginning, it doesn't make sense why he was a lawyer for murder. Sky, layaway hits are very common. Yes.
That was Charlie's attorney at the time. So that was being done. And so they were all clearly, trying to be proactive in preventing any of the Adelsons from being arrested. So they had a joint statement and just declared the innocence of all the Adelsons. And they said there was no evidence against them. But obviously that was wrong. And at the time, though, they wouldn't have seen any of the file records to know that they're guilty. But if you look at that phone call from Charlie's lawyer to the hitman's lawyer, why would an Adelson that's a victim of this for their grandsons and nephew and whatnot, why would they call the hitman's lawyer to try to see if they're going to flip and if there's any way they can pay for their lawyers? So imagine that if somebody tries to murder your family or does murder your family, are you going to call up the lawyer of the folks that got arrested for doing that and say, hey, can we help pay for your lawyer fees? And anyway, it just shows that the lawyers believe that they were guilty as well.
Yep, David Oscar Marcus. Just saying.
Sarah Howard, I don't think he's going to be disbarred, but I think he get some serious sanctions. The fact that 2 murder cases are derailed, I've never heard of a defense attorney's conflict causing someone that's already been convicted, as well as somebody that was about to go to trial. The day of trial gets found to have an ethical violation, and that trial gets bounced as well. So one of the things the attorney's supposed to do is make sure that they're not impeding the proper administration of justice. And so having a conflict to cause that much hardship and damage to getting these trials underway, and then one of them that got underway gets reversed, over almost a year later, it's just such a black eye on the system down there. If he gets off lights, I would say he's probably looking at a couple year suspension at a minimum. That's what I think would happen in like Texas, for example.
He's got enough to retire on.
Yeah, Dana, I think they would try Wendy, Charlie, and Donna together and at least try to do that and leave it up to the judge if the defense counsel want to fight and have a separate trial. But I really think there probably wouldn't be a trial for all these folks if they charge them all. That's how you get the most leverage and intimidation on defendants, is if you just blast them all with indictments and make them all be locked up in Leon County Jail there and offer a sweetheart blue light special deal to the first one's willing to flip on everybody else. Patricia Burns, you're asking, could this have been Rashbaum's plan to get Charlie's conviction overturned? I don't think Rashbaum really understood this issue. From what I saw of him in trial, he didn't seem like he was really comfortable in a courtroom. So I think he just looked at it from the standpoint, hey, I can make a lot of money that I've never seen before, all these Adelsons. And he probably saw the big dollar signs and sort of wanting to get to the yes to have them all be represented by him.
Oh, he probably came across Ian's. He's laughing.
Katie Girl, you're asking of the hearing. I think you mean if the hearing results in a new trial, then appeal of that trial is still open. Well, what would happen is if whatever Judge Everett decides, it could always be appealed either by the state. As for example, if Judge Everett finds there's a conflict, then the state could appeal that to appellate level. But I would think that they realize that they're cooked on this issue and it's never going to stick on appeal. So they may just concede there's an ethical conflict or Rashbaum, and they don't need to have a hearing. They'll stipulate, and basically have by that stipulation, they could say we'll leave the outcome to the court, and the outcome would be that a new trial is granted. So I think it's going to be too hard of a pill to swallow for the state attorney's office to say, yeah, we agree he's entitled to a new trial. But I think they're going to come close to that just because it's going to be so embarrassing to have this litigated and them saying, hey, this is no harm, no foul. And then they're going to lose big time anyway. So I think to save face, they'll just try to stipulate to at least the basic minimums that this is a ethical violation and a constitutional violation at that. Berg itself is saying now they'll put Donna, Hart, Charlie, and Wendy all wrapped up together in one trial. This is what you've been suggesting for over a year. Yes, ever since I saw this case from the get-go, it's actually, well, in January, I think it'll be 2 years I've been saying that. That's like, wow, why haven't they gone forward on these other Adelson arrests and trials? Warflare saying, can they put the death penalty forward if there's a new trial to knock that smirk off his smug face? I don't think they are going to do the death penalty. I think once he's already been tried with a non-death penalty case, I don't think that you would ever see them going back. But it should have been a death penalty case, as well as Donna's should be death penalty case. All these Adelsons of Florida should be tried with the death penalty, I think. At least you put it on the table and make them fight for their life.
Yep.
Strike some real fear in them.
I agree.
Make them fight for some kind of leniency by flipping on others. Tiffany Nicole, you're saying you don't feel sorry for Charlie or Donna. I don't think anybody does. But does that mean Daniel owes them a refund? Boy, I would say that if he doesn't offer him a refund, he's surely going to be sued over that. That's what I would expect. Yeah, Rusty Tugboat, you're saying, when he back on the stand at least 2 more times. Well, if you do this one at a time approach, I mean, they could be, let's see if they go 2 years out for Charlie's, 2 years out from Donna's, or if they do one at a time, then you got wait 2 years for Charlie to get convicted. Then are you going to wait for that conviction to stand before they indict Donna? But Donna, they can't let her stay in jail for 2 years without that being some kind of speedy trial type of issue that I think would be raised. So I think both are going to have to be tried really close at the same time, depending on if, they get new counsel and get them to flip. That would be something that would speed this thing up.
Jesus, this is disgusting, guys.
JC, you're asking, Rashbaum can't possibly get with what he did. Can he just get a slap on the hand? I don't think so. I think, like I say, the burden this is put on the state. Keep in mind the ethics committee board members, they would be up there in Tallahassee as well. So this is in their backyard. So if they just basically poo-poo this thing and make it look like it's no big deal, I'd be really shocked. But who knows? It's Florida, and
oh my God. I cannot believe this.
Lisa Bailey, you're asking also about justifying disbarment. I don't know about the Florida history of disbarment, but Normally for a conflict, that I would say I've never seen somebody disbarred for a conflict. That's more like a suspension kind of thing. If it's real aggravated, you really can't have a more aggravated conflict than this. And so with that being the case, I think, you know, it's in a lot of states that could maybe get in a disbarment type situation where he's disbarred for life, not subject to reinstatement, or maybe subject to reinstatement after 5 years or something. But
Top Cat says, I'm a bit more relaxed now. I know there's at least a stipulation, hoping that is enough to stop this in its tracks. I think what I'm more angry at, guys, is the fact that the damn state attorney's office is doing one at a time. And now they've basically set this back, what, almost 6 years? This is insane. Crime and Coffee Crew, Wendy is going to have to spend on lip fillers and Botox for the next 3 court cases. Yeah. Deb says, if Charlie and Donna both are tried at the same time, then they will be in the same courtroom or separate. And can they testify against each other? Yeah, they can testify because they'd have different counsel. It's basically would look just like Katie and Sigfredo's trial, right? Oh my God.
I just can't say and don't really know for Florida. Wesley John Holmes, you're saying trying together leads to more problems, calling each other as witnesses. Well, but the thing is, let the court decide. And what happens is if you charge all these defendants at the same time, you'll have ones deciding that, you know, look, we're not just all circling around the wagons, the Adelson wagons around one at a time defendants. If you're all these 4 Florida Adelsons are arrested at the same time and they're facing their own trial, then that's the thing that's going to really make them think about saving their own hide and not worrying about another family member. So there are advantages to doing it that way. And like I say, even if it wasn't a joint trial, at least arrest them and charge them all now rather than later.
Oh, JJ, I know. You got to find laughter. You got to, or we'd all go bonkers. Carmen Crawford Crew, I'm not taking this lightly. It is devastating. Just am upset. Using humor. Absolutely. I agree with using humor. 100%.
Carla Stewart's asking if granted new trial, would Charlie use his appellate attorney to represent him in his new criminal trial? No, his appellate attorney is strictly that. He's an appellate attorney. And so this is something that he's going to have to find somebody else. It's going to be somebody out of Miami that's got a lot of flash and pizzazz and, you know, trying to relate to a Tallahassee jury. Is he going to find somebody in Tallahassee? I mean, I think it's going to be somebody maybe outside of Tallahassee and maybe like Orlando or Jacksonville for both him and Donna.
Morris.
Cheryl Crawford, I think, you know, that a lot of that's dependent on if they're both going to fight it, then it can be depending on who's which attorney is ready to go sooner. That's really what it's going to come down to more than anything. I think even though Donna's still facing charges, she doesn't have an attorney yet as far as we know. Charlie will have his probably have his case tossed and restarted within a month or so. And basically they're going to be pretty close anyway. So it's going to be a neck and neck race, I would say. But maybe they'll get a lawyer that gets them to flip. Janie Garnett, you're asking if Charlie was allowed to see Donna when he's in Leon County Jail. No, I don't think he was. I mean, he should have been. I don't think they're going to cut him any favors like that. So it's highly doubtful. Dana, you're saying how embarrassing for the judge. Yeah, Judge Everett's a great guy. I really like his temperament, but he really missed the boat on this one. It's really something.
Oh, good question, JJ.
Sally H, any fresh words for Jack? I've already said what I need to say about that. I'm not keep talking about that. But you know what I've said in other episodes, who's to blame? And it's just really unreal. You can't make this stuff up. This case is so crazy on so many different levels and degrees. John Calabrese, you're asking, does he walk? No, he's not going to walk from this. He's just going to get a new trial. And so he's going to start all over. He's going to start all of that money he spent on Rashomon. I'm sure Rashomond's not going to give that back right away. He's going to probably fight him on it. And so remains to be seen who he gets for new counsel. But you're not going to have Rashomon ever representing another Adelson again. I guarantee you that. Okay, Rosemary Romero, you're asking what are the chances Charlie and Donna will get off on a technicality because of ineffective? Well, ineffective assistance just means you get retried. It doesn't mean that you're going to have your case completely dismissed and a guilty party can walk free and never face prosecution again. So it's just a reversible error. That means that it'll go back to trial court. They can start all over. It's just sort of like what's going to happen with Charlie here. Lynn Strauss, you're saying, do I think the judge filed this to protect himself? I don't know what you mean by the judge filing something. I think what you're talking about is the order that Judge Everett signed, bouncing these 3 lawyers for Donna from representing her. That's something I've been advocating. And in fact, if you look at it 2 weeks beforehand, I had a title that said Judge Everett must remove all Adelson lawyers. So that's what, and I mentioned case law at the Wheat case, Wheat versus United States case, a 1988 Supreme Court case. And so that's all the authority you needed to do that as a judge. So anyway, he finally did it after this long time, but I don't think he's going to miss it up with Charlie.
I would really love to get Charlie phone calls right now because I can imagine he's been talking on the phone.
This time, I think he's going to find that Rashomon was conflicted and grant a new trial. Unfortunately, I think it's hard for the judge to have to admit that mistake. But if anybody's got rock solid integrity there, I think Judge Everett is going to do the right thing and have the courage to do it. Okay, jumping ahead here. Let's see.
John Steinbeck just gave us a shout out, guys.
Deb C is saying, could there have been a mistrial during Charlie's trial once Rashomon put Donna and Harvey on the witness list and removed them? What a waste of time. I don't think anybody saw this conflict of interest at that time. So no, there wouldn't have been a mistrial because nobody saw this being a percolating issue. Lorraine Piscatelli, you're saying, call Jack Campbell and ask him to arrest all of them, Wendy, Donna, Harvey, and Charlie, do it all at once. Yeah, I think they know my opinion down there. I'm led to believe that anyway, that I've made some strong comments about Jack Campbell. And so I'll just leave it at that. And I'm not going to keep getting fired up about that. I mean, it speaks for itself, and it's so obvious that that there's multiple blame across the board, not just Rashomon. Well, what happens with Wendy now, Janie Garner, I think she should be arrested ASAP. This has been long overdue. State Attorney's Office needs to get with the program and get this thing moving and quit delaying this case any further. So. Dempsey, you're asking if he gets a new trial, can he have a different defense and get away with it? No, what he said in the first trial, he's going to pretty much be locked into that as well. And that's why I think any attorney half their worthwhile is going to go ahead and try to negotiate some kind of plea agreement and try to talk Charlie into that. So if Charlie doesn't, then it's like, okay, well, you can't manufacture a new defense. No, I don't see any defense attorney saying, well, can you come up with a better story than that, Charlie? Because that one was ridiculous. No, the evidence is too overwhelming, and he definitely will be convicted. Thanks, Kathy. That's nice of you.
I do though, guys. I like Carl and John. Yeah, I guess that's all we can
what?
do is make jokes and state.
Owasso Egan saying, too bad they can't try Donna and Charlie together, but it would.
Tennis girl, oh, I'm so with you. I guess that's all we can do is make jokes. The state isn't going to do anything. Tennis girl, I agree with you 100%. I am so fed up with the state. Get your shit together, guys. James Owen is calling Charlie right now. Oh, God. Will the new jury know his last story? Guys, I would almost bet this ain't happening in Tallahassee. I would bet on it.
Would be conflicted though, right? Well, that's something that you can try co-defendants at trial. Sometimes they're separated, but leave that to the judge. Try to get them both to be tried together along with Wendy and Harvey. Why not? Why not at least try it?
Well, I know Carl's not going to strike me now. Oh,
JJ, you're folks, you're saying.
Sorry, Carl. I need to look. Tim J said he knows who will likely be Donna's attorney. I'll be curious. I bet he knows who Charlie will pick too. Yet they haven't announced it yet because it's not in the docket. I look every day. At this point, I bet Owens would find Charlie easier to deal with. I would get. I don't think so. Not at this point. I can't imagine how they are going to find a jury for both Charlie and Donna after Charlie's already been convicted and has to get a new trial. I just don't see it. Crime and Coffee Crew, are you aware of the murder at the flower store in Toronto on? No. When did that happen, JJ?
And folks, he never predicted this for Charlie's trial, Mr. Monday morning quarterback. If you're talking about me, I would say that I don't share everything that's helpful to the defense. You know that. And so this was a concern I had all along in this case, and Rashomon being conflicted. So no, I'm not going to publicly admit that that there's some reservations about it. I had more reservations than what I even said about Donna having Rashomon on the case, but I constantly made reference to that. And so anyway, I don't know if you're trying to say I didn't adequately predict this, but if you look at my other predictions, I think you'll see that.
Oh, good question, Latu.
That I've been pretty consistent.
Asking about Judge Everett.
C-Star, you're asking, will he need a public defender? No, he's not going to be able to get a.
They can't get a public defender, guys. They've got money. I have a story. I met the sister of the murder victim at a lighting store last week. Oh. Geez, I would love to get some of these people on that are local in my area. JJ, are you from Toronto? Well, Monday morning quarterback, why didn't you tell Georgia? I agree with JJ. Everybody said Rash should represent him is a bad idea. Yep. Oh, you're so close. We should have coffee sometime.
The public defender, because I don't think he's at the point he's indigent yet. Public defenders are only represent those people who are so poor they can't afford to hire an attorney on their own. So I don't think that's the case at all. Yeah, I'm sure Don is happy that Charlie is getting a new trial, but now they both got to start all over from scratch. So Charlie and everything he went through, it's all for naught. That Rashomon is in his representation is gonna call these things to be reversed. So.
Tennis girl, in what area of the States are you? Carl, crime and coffee. Answer crime and coffee, man. Come on, you can do it. John, pull it up.
Letterman's Bureau, you're asking, could Rashomon be responsible for paying for another retrial? Why should the taxpayers be on the hook again? Yeah, they don't do that to lawyers in the United States. So if he's ineffective, then that's states is gonna have to retry it again. All witnesses are gonna have to go through that same hardship. So Margaret, you're asking how does this affect Donna Jenna Rashbaum's co-counsel? I don't know what you mean by that. There are no co-counsel now in this case for Donna. She doesn't have any counsel, period. So the judge removed all co-counsel that Rashbaum had. So
In Houston. Ian is sending pictures of being.
Jane Kreisman, yeah, I think Pleasdale is remotely possible, but you got to get the right kind of attorney in there that can talk some sense into Charlie. But
I gotta show you.
who knows? Who knows if Charlie's going to wise up and decide to do the right
What
thing?
Ian sending me.
JC, you're saying he's had a bad taste of prison life, so he might just cave. Yeah, I mean, that could be a good impetus as well. I think the fact that he's so disgusted with Wendy, and I think he really blames Wendy for his conviction more than anything. There could be maybe 50-50 chance he flips on Wendy. And think about it now. He's starting from scratch. There's no conviction, murder conviction over his head where he's not going to get that much shaved off if he agrees to flip on.
I'm telling you guys, whenever this Donna trial or Charlie Donna trial or Charlie trial, this girl is going to wherever that trial is being held. And what we should do is rent a big house, coffee crew. We all rent that big house and we take on the trial together.
On Wendy, I would think he's going to just beg at the chance to testify against her in exchange for maybe getting, 25 to 30 years, maybe 40 or something, rather than life without parole. Yes, I'm so tired. Yeah, they will definitely be staying in jail during this whole time. Charlie will be released from prison and come back to Leon County Jail. I'm just laughing about this comment here about June. Carol Mitchell, you're asking, is now the time to assemble all Adelsons and put them on trial together? Yeah, that's what I think would be a smart move for the Florida Adelsons. I agree.
Way to go, Ian.
All right, jumping ahead here.
I should have waited till he was almost to the bottom.
Okay, first of all, Cindy.
Hey, Penny. Maybe it's petty, but George has been gone almost 5 years, and this guy is still accusing him of beating on Sarah, and it makes me want to scream. I think you're talking about, sorry, Penny, if I'm getting this wrong, you're talking about her lawyer saying that? It makes us all want to scream. Tennis girl 101, I only comment on people with 3 initials. Yes, at JJ Don, I unsubbed. Okay, get back to Carl.
Petrovsky, you're saying, why didn't any YouTube lawyer catch the conflict and put a spotlight on it? Okay, well, first of all, we did not know that Rashbaum was really represented by, at least didn't have that foresight and recollection that Rashbaum was representing Don and Harvey way back when. And so, as you're talking about the conflict with Charlie, there was no, we didn't know for sure that any Adelson would be prosecuted ever again. So if the state attorney's office knew that they were going to prosecute Donna right after Charlie, they would have been in the best driver's seat to say, hey, look, Rashbaum, you represented Donna and Harvey, and now you're trying to represent Charlie, you're going to have a conflict there. So they're the ones that should have raised that from the get-go if Rashomon wasn't going to raise it. And then the judge should have said, you're right, this is a totally problematic thing, Rashomon. You're so wrapped around the axle of 3 different Adelsons, and if the state intends to charge other Adelsons, that's going to be the reason that you're bounced off this case, because your main loyalty looks like is to Donna. But because we didn't know that at the time, now here you got after, as soon as it became a real issue was when he represented. I'm talking about Rashomon. When Rashomon comes in and represents Donna, when that happens, then you have the direct conflict between Donna representation and the Charlie representation. So that's when it really became a front and center thing, because without Donna ever being arrested, it would have never been an issue, right? So it potentially had an issue, and if it's potentially an issue, it's not that big a deal. But sorry, I'm just not going to say something about Charlie also having an appellate issue that can be reversible. But once we saw Donna's getting unraveled, the same kind of thing could apply. So anyway, as I've said from almost 11 months now, Rashomon should not have been representing Donna. Took that long to get him bounced. So, and now he's going to be bounced off of Charlie's as well. So Mandy Strong, I don't think it's an intentional conflict. I think it's something that just people drop the ball on, especially, Rashomon should have known better. But there's plenty of adults in the room for the blame to go around. No, trial be tedious. Yeah, but you know what? I mean, there's I'm hearing reports that a lot of people say, you know what, this go at one at a time against an Adelson is working, and it's worked successly.
No, it hasn't.
I heard that from a lawyer on YouTube a couple days ago. Somebody pointed that out to me, and guess what? Now they're going to start from scratch, day one, ground zero again, and none of the Adelsons are convicted. So it's a conflict issue. Like I said, wouldn't have happened if they would have arrested multiple Adelsons at the same time. I'm so tired. He can't change his story without perjuring himself. That's correct. He's not going to come up with any kind of different stories. He's pretty much like.
No, JJ, Jane is joking. It's a joke. It's a joke.
Locked himself in. Snow remover. Normally you have a response from the state and before the court makes a determination. So you have appellate lawyers representing the state of Florida on this matter. So they'll give a response initially. And I expect, I would think that they would agree to have it returned to the trial court and have that address the conflict, but it remains to be seen.
Oh, I guess that's my bad. I'm paying attention to what Carl's saying. Sorry, guys. That's my bad.
Yeah, Johnny Walker, I am saying he's locked into his extortion, which it doesn't meet the definition of extortion. So I call it a robbery on a payment plan. No, I have not shown you the appellate document that Ufferman filed, and not sure if I know how to do that on YouTube, but it should be published on the court system by tomorrow. If for some reason it wasn't tonight, I had to get a bootleg copy from Steve Cohen, as I said earlier.
Oh, okay, guys, we'll have it tomorrow then.
Cupcake, I think it will be overturned. I don't think it's a high possibility. I think it's pretty much a done deal in my book. I think that if the judges understand constitutional requirements, I think it's a done deal. I can't say that for sure. Obviously, I don't know. I don't have any inside knowledge on the judges' predispositions to rule on anything like this. I don't know who they are. And I'm just telling you from my experience working with thousands of criminal cases over 30.
What is tomorrow? So tomorrow, the outline of what they're put forward to the review should be in the docket tomorrow. Steve Cohen gave Carl a bootleg copy. I want a bootleg copy. Me too, at tennis school, exactly. I lived in Boston, and the whole KR fan base circus enrages me. Yes. I stayed right away from that, guys, because that was scary. I'm thinking the sheriff is going to be somewhat same. I left another channel when the creator was abusing subscribers. Oh, I know which channel you're talking about, JJ. Yeah, that was the stream, and Jane Cushman, I was not on that live, or I probably would have gotten same. I'm sorry, guys. I'm sorry people got banned. I really do. I don't agree with. This is the one time I hope Steinbeck is wrong. Wishful thinking. Hasn't been wrong yet.
Some years that that I think he will get a new trial. So Feisty, go ahead and say that. You know, I'm not happy that that's the case, but you know, there is such a thing as a constitutional standard. We can't have people convicted with lawyers that are conflicted to such a degree that people are denied the right to a fair trial. So it's really a legal issue, and it's not so much a personal issue. But
What is up with this? No wonder we all congregate here with Rochelle, Crime and Coffee Crew. Because we're small. Let's face it, we're a small channel, but there's more interaction, so I'm okay with that. And sometimes we get nasty people, and Crime and Coffee Crew, I wasn't banned, just left. My humor wasn't appreciated, but your humor's appreciated here.
But obviously the personal consequences and the emotional consequences are severe and drastic for the victims of this, the Markel family.
Oh my God, I just can't believe they're going.
Mary Patterson, you're asking, do I think because Charlie Edelson has money, he'll be more strategic going forward legally? Well, it depends how good of a lawyer you get and what kind of money you can buy with the lawyers down there in Florida, and how much you're willing to have somebody tell them the truth. Keep in mind, as I've said, if you got a lot of money at your disposal, lawyers want to go to trial, and they're not as inclined to tell you the truth. They're going to tell you, hey, fight this, we can win. Because if and they're going to demand, let's say, $1 million off of.
Tennis Girl says, yes, it's small now. You're almost at 3K and will get even bigger. I'm addicted. I've even watching this jackass. I'm so addicted to this community. Oh, well, thank you. Thank you. I don't even know what our numbers are today. Good point, JJ. We love to joke around and be absurdity of it all. Yeah, but you have to joke. You have to laugh, because honestly, come on. If we didn't laugh about this BS that's going on today, 2.9K. Oh my goodness. Wow. His new lawyer would be locked into his robbery on a payment plan. Speaking of that, please like and subscribe. 2.905. We are 85 away from 3,000.
A wealthy defendant, if they say, hey, give me $1 million and I'll work a deal for you, they're going to go, what, $1 million to cut a deal? I'm looking for a new lawyer down the street. So you'd lose out on a lot of money. So wealthy people, they're going to want to have lawyers that
how many YouTube lawyers stop talking about the Adelsons, just waiting for that phone call? That would be hilarious. Let's watch how many YouTube lawyers stop talking about the Adelsons.
Tell them what they want to hear. For the most part, is the way I look at it. And in the end, they wind up getting the worst representation. And this is an example of it.
I don't think Cutie Patootie does murder trials. So thank God, because I don't want to have to hate him.
John, you're saying
oh no, Charlie grabs Sarah's thunder. I'm calling for a cage match. Charlie versus Sarah. Sarah will extort him and claw him a new one. Sarah would win that fight. I would bet on Sarah. I would.
with the video on STS we used against Rashman, as he lied publicly. We don't know for sure that he lied. That's a pretty bold statement. He did say he had a signed waiver, and if he got botched the signing of it, Even the motion today said there was not a valid waiver because it was never signed. It was discussed with Charlie, apparently verbally gave consent, but Rashman never had.
Tennis Girl, you have a perfect time slot. Until at Crime and Coffee Crew, I was only watching, well, I'll say inferior type channels. As you can see, I've been coming on a little bit earlier, guys, because I'm not well. And I need to be taking my medication earlier than what I was. So I've started coming on a little bit earlier, but if you all think that 9 o'clock is the best time, please let me know. I'll try to work it out. But I've been trying to come on, like tonight I come on at 6. And it seems like it's gonna work out time-wise for me, but Charlie is not going to do anything but spend more money. Yeah, they're gonna be drained. Charlie is a wimp and coward. Sarah is a rattlesnake. Yeah. At Tennis Girl 101 is perfect for a time zone. Oh, please take care of yourself. Whatever works for you is fine. I'm with Deb's like I like the earlier time, maybe 7 or 8. Yeah, that's where I'm trying to. JJ, thank you. Yeah, I'm trying to be, because in there it gives me the proper amount of time, and I'm obviously still got to work, so that's got to be taken care of too. So I'm just trying to find a happy balance because I still want to be here with you guys, but it's just my times have been changing up.
Had the written waiver, but in the end, it doesn't matter because even a written waiver you can't waive a constitutionally ineffective counsel. So with that being said, that's not going to resolve the matter. Okay, let's see. Yeah, in his will, Dan's poor parents, they must be so disheartened. Yeah, it's a real tragedy. It's a real tragedy, and but anyway, I could start going off on a rant, but I'm not going to do that.
Oh, I think we just saw his girlfriend or his fiance.
Okay, let's see.
Through the mirror.
Now they're both going to stay in prison. No one's going to get out. So in any event, there's no way they're getting out. All right.
Oh, Ian must have said something funny again. Oh, she's pretty. Sorry, Carl. We just have to go back for a minute.
Okay, here, Janie Garnett, you're saying, can the Markell sue Donna Adelson?
I knew he'd have a pretty fiance.
There's no way they're getting out. All right. So,
oh, we missed her. I knew she'd be pretty. Let's go back a second, see if I can pause it right.
Anyway, I could start going off on a rant, but I'm not going to do that. Okay, let's see. Now they're both going to stay in prison. No one's going to get out. So in any event, there's no way they're getting out. All right. So
see her? Let me see if I can make this bigger. She's a very pretty girl. Way to go, Carl. Way to go.
okay, here, Janie Garnett, you're saying, can the Markell sue Donna Adelson and others for not doing their job properly and therefore allowing their son's killers to walk free? No, they have qualified immunity. They have to do something really extreme and outrageous and outside the scope of their professional official duties before you can sue a state official. So that's never going to happen.
I think so too, Patricia. She's mellow.
Yeah, a lot of questions about Rashman losing his bar card. I don't think that's going to happen. But Could it happen in other states? Yeah, I just don't know about Florida. I'm not going to speculate on that. Fletcher Boy, could Charlie and Donna waive the attorney-client privilege to expose potential wrongdoing by Rashbaum? Well, if Rashbaum's brought in a lawsuit or he's facing ethical charges, I don't think they're going to bring in Donna and Charlie because they're going to be locked up, so they're not going to be witnesses that way. And I would say that you don't need that waiver to properly do the ethics call and decision on what should happen to his license. So I just don't see that. Adelsons really aren't the ones that are going to be driving the train on this. The state bar judicial committee will be the ones to the ethics committee will be the ones that are going to be looking at this, determining what to do. And what they do is in all states, they provide notice. There's a complaint and the attorney has to respond. And if it's if it's still something that looks like it needs to be addressed through a formal hearing, then they'll put the attorney on notice, and they have like a mini trial to determine what was done wrong and if anything was done wrong. And if there is a finding of an ethical violation, then they'll have a recommended sanctions, and then that will get teed up to the Supreme Court to make a final chop on it.
I don't think we're getting answered.
Lindemont, you're asking where the feds. This is embarrassing for the poor Markells.
Oh,
Yeah,
no.
they did have all this FBI involvement with Special Agent Sanford down there, but I guess the federal prosecutors down there, the U.S. Attorney's Office, which is actually sitting right there in Tallahassee, so that's right under their nose as well. So it's just mind-boggling how this case has been languishing and not proper attention given.
Oh, please don't let the Fed step in and take this. Oh, dear God, could you imagine? Leah, you made it back. I've seen you over in Carl.
Manny Strong, you're saying, can Charlie change his defense now? What if Rashbaum recommended that wackadoodle story to save his dear Donna? As an attorney, you're not supposed to manufacture a defense for the client to come up with. I think attorneys do that. But if they do that, that's really something that is highly unethical, and you could lose your license for that. So I would say that's not something that I'm going to speculate and say Rashbaum would do that. I think Charlie's the one that's the wise guy and thought he had this things worked out so good. So don't see this as a something that Rashbaum came up with. I would think as an attorney, for sure this thing is so ridiculous. So that there's no way you can win the case. So I don't know why. I guess Rashbaum doesn't have the experience level on violent crime cases to, if he really was telling Charlie that he won.
Shiraz just asked a good question. Hopefully Carl's answers. Carl, your odds on plea deals. And then the two said, imagine all three on trial at once and Jeff Lacoste is called to the stand. Epic. It would be epic.
In the case because he scored a 95 on his testimony. No, Charlie's not getting out of jail. If he gets a retrial, he's just going to come back to state court, Leon County Jail. It's going to start all over again.
Oh, you seen it? He's wearing a what? No.
Yeah, the double extortion defense absolutely won't work right now. Well, it never worked before. So it's the worst defense you could ever come up with in any kind of felony case. And we even got more evidence now, the conversation between Donna and Charlie, where they were basically saying that Sigfredo Garcia, when he got arrested, that he was probably dealing drugs with
Marie?
Deanna Rashbaum, and that's why he got murdered. So why would they have that internal private conversation if there really was this robbery on a payment plan as being what was the real story?
Well, he just announced he got
Cupcake, no, Charlie's conviction wasn't overturned. I'm just predicting.
I'm saying this right now. Mr. Carl Steinbach, if you got married without telling us, that's not right. You said you got engaged, not married. I wouldn't. Yeah, that's right. He mentioned he was with his lovely fiance. Maybe they got married. He didn't say how long they were engaged for. God, if Carl, if you're on your honeymoon and on YouTube, that is not a good look. That is not a good look, sir. Not a good look.
Predicting that's going to be the case,
I'm
probably for
not
the next
muted.
30 days or so. I just don't see this as being something that's going to survive appellate scrutiny, and I think Judge Everett's going to make a similar decision to what he did on Donna's case. Rashomon was up to his eyeballs swimming and drowning in this conflict, so.
Gamma, welcome back, Gamma.
No, public adjuster Charlie's not going to be able to post bail. He's going to stay in there just like Donna till his trial.
Looks like I got to write another letter.
Okay, let's see. Don, you're asking, can this affect Katie in any way positively, Carl? Well, you know, Katie's testimony that helped convict Charlie, you know, all that was for naught. And so I think maybe what will happen is if Charlie does decide to go all the way to another trial, that, you know, maybe Katie's going to be more emboldened to tell the truth and give more details than she gave earlier. So it remains to be seen.
Get a plea deal. That's my question, Carl. Answer my question. Oh, you've been here. Sorry, Gamma. I don't want to see his honeymoon. Very happy for him, yes.
All right, let's see here.
But I don't think he should be on YouTube when he's on his honeymoon.
Jill Argos, you're saying none of this is George's fault. Well, go look at some of my past recent videos in the last month. I explain that.
Carl's being on his best behavior tonight.
Yes, Lana, they can offer Charlie a plea deal for the second trial, maybe flip on Wendy for a deal. Yeah, that could happen.
But what about...
It might be something as good as a 50-50 chance. Who knows? You're talking about personal decisions, and to have Charlie admit to murdering his nephew's father, that could be a really hard thing to do. But if he wants to see his own son and never have a chance of doing that, then that'd be a no-brainer. Flip on Wendy, flip on whoever you need to, including Donna and Harvey. If he flipped on all three, he'd be getting out the soonest with that.
I'm going to try again, guys. I'm trying again.
Sharon Shipley is asking, do I think that there are still political strings being pulled behind the scenes? I think that Adelson connections in Florida have dried up. I think people look at them as toxic now, and they don't want to be associated with them in any way, shape, or form. So I don't think that's still existing now. I think it's just a matter of other things I've talked about on this channel in the last year plus.
I did both times.
Cece, you're asking, will Dan be called to testify? I know about Donna was leaving, et cetera. No, you're not going to have an attorney be called for something like that because that'd be attorney-client privilege. If the client turns around and tells other people, that would not
he wasn't representing
subject the attorney to be called in for that. But
he wasn't.
You know, maybe his conversation telling her she should not flee, maybe that could be something that, as Stephen Webster said, could be something else that they add as a ethical allegation against Rashomon. It remains to be seen.
Come on, Carl, you can do it. Come on, Carl. Do it. Do it. You want to do it. Honestly, guys, if he pulls me up, it's the first time he's ever answered one of my questions.
Yep, JC, get the Ailsons locked up. I agree. Stravitis, you're saying, shouldn't Judge Everett be recused as well? With Judge Everett, just because he made a bad ruling does not mean that he's or delayed a proper ruling is more likely and didn't screen and bounce Rashomon from the court almost 11 months ago. He's not going to be recused because that's not a personal conflict. Judges don't have conflicts like that with defendants. But if he did have some kind of personal history with one of the parties, and that is what happens when judges need to recuse themselves. JD, you must have not seen my other channels. The last 3 segments I had, I've covered this very heavily about the prosecution's involvement. So I'm not going to cover that again tonight. I get too ticked off.
Yes, you do. Yeah, and
Okay, Maya.
yeah, and Carl got out as the storm was getting worse. They decided to leave, got on probably the last plane leaving, and went to New York. So he said before, like, because we seen the live that he was on, it was getting windy and stuff like that, and they decided to leave.
Again, saying I've seen a 1-by-1 prosecution of co-conspirators who murdered a young kid. They still arrested all in the same time, even the shot caller. Yeah. So the thing is, you arrest them all around the same time or at the same time, and even if you give them separate trials, at least that's forcing them to do a circular firing squad. So if you just do one at a time and let's see how that trial comes out, then maybe then we'll have an.
Oh. I used to watch a Smallish channel, and there was a co-host on it for a little while, but she left not too long ago because she was getting engaged to her boyfriend, Carl, and that woman looks just like... Is she a lawyer? Was she a lawyer, Patricia? Because he said his fiance is a lawyer. Interesting. Then they went to NYC, Carl's engagement tracker. Yep. He actually said it on his next live when he was in New York.
Enough courage to go after the next
NYC
co-defendant. No, you got to get them all nailed down at one time.
I agree, Carl. Just put the hammer down. Be done with it.
Yeah, JC, you're right about that. A lot of his questions of representation of both Adelson seeing the conflict. I couldn't believe Rashomon allowed to do this, but anyway, that's something we'll never understand how this got so far down the tracks.
I put red question marks, Carl.
No, Charlie's not going to get out on any kind of bond. Marta Fonda, he's going to be locked. He's going to be locked up there in
We need to find
Tallahassee, Leon County Jail. Yeah, Mandy, if Rashomon wrote the script for Charlie, that would be like he would be disbarred probably for that. If you basically coach your client how to lie and you got it in writing, I don't see that happening. Ethically, from I'll just say, like, for Texas, if I have a client that I don't believe and he's not telling me the straight truth on what really happened and to get him charged, then if the client still insists on going to trial, then I can think that they're lying, but unless they admit to me that they're lying, I got to let them get on the stand and go ahead and say their story, and that's what I'm supposed to do. But if they tell me, hey, I'm going to get up there and lie, Carl, what kind of questions I ask? And these are the ones, or they tell me what questions I ask to help establish a defense that's a lie or a major falsehood. I'm not going to be involved in that. That would be unethical for me to take part in that.
Come on, Carl. You can do
Carol Mitch, you're saying, if not now, the time to arrest all citizens, when is? Does you ever have any say in this ongoing nonsense? No, the judge is neutral. Judges do not weigh in on when folks should be arrested. If they're presented a warrant and stuff like that, then the judge have a neutral, detached responsibility to evaluate the evidence presented and go ahead and make that call. But no.
Shiraz, we've been here. We're watching you over in Carl. We're watching everything. We've been following Carl since he started. I wonder if Marcus will reemerge for Charlie. Probably if he doesn't take that stupid defense, I would see it. This is insane. This is a freaking circus. And they call me the circus freak. Imagine.
definitely not Judge Everett's responsible. I think it was up to Judge Everett. Yeah, he'd make more arrests for sure.
It's
That's
not
not
up
his
to him.
role.
Don, just
Again, from Cease
fiance.
Providus, you're saying who will be representing on our 12 December hearing. We don't know who's going to represent her. I think it's actually the 10th of December, 12/10, if I recall correctly. Anyway, it's around that time frame, so I think that it remains to be seen. But that's a lot of time to be sitting there trying to find a lawyer.
We are watching a live stream of a live stream. Welcome to the Matrix. Tennis girl got a wrench. Yes, she did.
Yeah, we don't know how much Astra Moon is actually. How much did Donna pay Alex? We do not know. That's a number we're not going to know off of any information that's made public. But my guess he's probably made 400,000 at least on this.
I was
Maybe
saying
600,000.
That's what I thought. 450, I think.
Yes, that's a good question, Carla. The new evidence discovered by the state after they arrested Donna can be used against Charlie in the new trial as well. So in that sense, some of the evidence is stronger, but yeah, it's definitely something that's it's going to be that much easier to get a conviction, assuming you got a lot of the same witnesses available. Yeah, John said it right there. It's just really unreal. You can't find another true crime case like this. This one is it's got some legs of its own, and it just keeps going on.
Carl, I have question marks. I've got two of the same question.
Yeah, again, you're asking about Jack Campbell. I'm not going to talk about that tonight. I've already talked about that.
Yeah, it's like they don't have endless.
Jumping ahead here,
right?
Let's see.
They don't have endless money.
Mo Roma, you're asking if Judge Everett make this right by overturning it, or does it have to go through the appellate court? I would say that this has to go through Judge Everett. If it's granted,
the way here, simple like Patty. You know how Patty runs. It's the same here.
if it's agreed by the appellate court, the first district court of appeals there in Florida, if they agree to have this case sent back to the trial level Judge Everett, then that's something then that gives the judge at the trial level the opportunity to address this issue and do some fact finding. But so I think the trial courts will grant this.
Sorry, guys. Jane, I want to read it. Maybe we can watch this together. You're invited to sit in on my chat with attorney Carl Steinbeck tonight on YouTube. Half hour from now, we'll be discussing what might be next in the case of Dan Markel, murder arranged by his ex-brother-in-law and allegedly his ex-mother-in-law. It's an important case to pay attention to. And then there should be more. There should be one more. Where is it? I'm just saying that I thought I heard Georgia say on the day of the case derailed that she had nothing at Top Cat, but maybe I misheard. I don't know how Carl selects his questions. I thought I had one most folks had, but he didn't answer. Maybe he thought it would help defense somehow. Maybe all I'm asking is, can Katie get another sweetheart deal? Ian was so excited, Shiraz, that he made Carl laugh, that he took a screenshot of it and sent it to me on Discord. It was so funny. Jane, do you have a channel?
Request. I don't see any problem doing that. It's just going to help this issue get resolved quicker and help Charlie get a second trial much faster than like I say, if it works its way through the appellate court system. Kurt, absolutely, Wendy could be arrested in spite of these developments, and could and should and hopefully will be
up on the list. I had a question around where Kurt was.
Sally A., can you please clarify that Judge Everett was the third lawyer on this trial? There were two other judges before Everett. Yes, Judge Everett, we had Judge Hankinson, that was a judge initially, and then we had Judge Wheeler. So the the issue with Charlie having conflicted counsel, he was the
Mike
first
is
person to
not
be
far from
arrested.
here.
So Judge Everett was the first one that could have, if he knew about the fact that Rashbaum was representing Donna previously. But like I say, nobody was in the driver's seat except the state attorney's office to really know if they were going to charge Donna down the road. They should have made that determination, know that they're just waiting to build a case against her. But, you know, they kept us in the dark about that. But they were really the ones that said, wait a minute, Rashbaum was right. We know Rashbaum was representing Donna previously. So why is he now representing Charlie? And that should be a conflict. But they never saw it even after he came back to Donna again, representing multiple Edelsons at an actual murder trial. Did not even face the state attorney's office or the judge. So anyway, it's we know where it's at now and what that led to.
I think so. Come on, Carl.
Yeah, it's been such a long time, hasn't it? So imagine that you have no Edelsons arrested if this gets bounced. No Edelsons, I should say, convicted after over 10 years. That's so shocking.
Come on, Carl. You can do it.
Yeah, McGrady, I've already talked about that. So you guys are, I'm not going to rehash that. You can look at some of my past videos in the last month about that.
Come on, Carl.
Okay, I'm going to go for a few more questions here. Let's see.
It's like winning the lottery. Come on, Carl.
All right, Rosemary, you're asking, would this have ever happened if the prosecution never put Charlie Edelson on the witness stand? No, it would have never been salvaged because this issue was still such a major thing hanging out there. So I would say that that just brought the issue sooner than later, because otherwise what would have happened is it would have been a year and a half down the road before the appellate court would have made a ruling reversing this case for the conflict that Rashbaum had. So this is speeding it up. So them having on the witness stand, I think is a good thing to make them start over for having this thing so botched up.
I'm trying one more time. This is 3 times.
Okay, here, let's see. CC's asking, Dan belongs to a law firm. Will they be involved in any of this? Well, in terms of like the ethical complaints that Rashbaum's had to respond to, that's him and him alone. The firm does not drug into that. If there's a lawsuit against Rashbaum, then of course the entire firm would be on us if there's a civil suit. Patricia Winders is asking, do I think this has been planned all along? The Edelsons know him well. He knows the law. Well, you're saying that's debatable. I think this has been planned all along. I don't, I can understand why folks can think that, but I just don't think lawyers are really that calculating in how to be able to get a client off, even if it's a client they really love and think of supposedly as a mother. But I don't think for a second that he thought of her as a mother. I think he's just doing his advocacy for Donna. And so no, I don't think they understood this conflict was going to come back and get them in trouble with the bar at all. Mm-mm.
I know. Good luck.
Yeah, Tracy, that's what I'm saying. I expect Charlie's case to be overturned, and I think he'll be retried. And unless he is going to cut a deal with the state. Rebecca Ross is asking, is discussing a client's case in public a bar violation? We have both express and implied authority as attorneys to talk about our client's situation.
I'm just going to, April, I've been watching it through Patty's channel while I'm at work. I rewatch some testimony at night. Rusty was on today. That is, I watched that handsome Rusty today. So maybe we'll get a chance to see Charlie convicted in person at Tennis Grow. Wouldn't that be great if they were both tried at the same time? That's what I was saying, Shiraz. I said, if it comes down to that, the coffee crew should rent a fairly big Airbnb, and then the coffee crew in the courtroom watching this. I think that would be an awesome idea.
We think is benefiting the client. We're not allowed to talk publicly to the detriment of our client's interest. We're always supposed to act in their best interest, even if the attorney-client actual representation is ceased. So, for example, if
because you know things are going to be rented like crazy, like it's and that. So I just thought, hey, if we got a house, rented it. Hell no. Hell no. No way, Jose. I'll bring yeah, more. Or shall behave. Let's get it. An Airstream wouldn't be big enough for the coffee crew. But honestly, guys, I really think that's a great idea. Like, if their trial gets, and I work for an airline and get some guest passes, could fly for free, but getting to Tally tough, I'm going to be hoping for a change of venue. Straz, get the booze and bartend. And do a live stream. Glamping, yep. JJ and I, we live near Toronto. JJ lives in Toronto. We'll jump on a plane, or JJ drive down. We could drive down.
Donna was represented by Rashbaum, and then he's actually stopped representing her to go take care of Charlie. During the time of representation with Charlie, he still has a zealous ethical duty to preserve the best interest of Donna at the same time. So that's where you have this thing about like, whose best interest is he really looking out for? Charlie's or Donna's? And therefore, by him not wanting to call Donna at the trial to support the to have a corroborating witness for Charlie's, and it's just sort of one of those deals where
I think we need to start a petition and send
it just looks so bad that he's conflicted.
We demand justice.
And is conflicted. It's not just an actual. It is perceived. It is an actual, I should say.
Deb, where are you at? Yeah, drive down. We'll meet you in Texas on the way. Take I-10 all the way to Tally. Road trip. Jane says, I have 2 sleeper sofas in DC on your way south. Nice. DH, I probably drive. I'd be driving from Houston. Oh, Madison, North Carolina. JJ, Crime and Coffee Crew, there are flower farms north of Toronto where we will go first. Wouldn't that be a conflict if Marcus represented Charlie? They never represented him. He represented him prior, but then I just don't see it being a conflict with him. I call Shotgun Shrez. Can I hitch a ride with you? That's what we should do, guys. Deb, I would pick you up in a heartbeat. In trial, Rashi was also defending Wendy more than Charlie. Made no sense. I agree. He was cleaning up her mess, right? He was cleaning up her testimony. Madison, North Carolina. In general, where are you, Deb H? Madison. Oh, yeah, let's do it.
Johnny Walker is asking about where I think that Charlie complained about a fair trial in Leon and considering the publicity, and Rashomon Drano, where they give grounds for a change of venue. I don't think there will ever be a change of venue for any Zeta Olsons. There's not enough Tallahassee folks that know about this.
Did he just say no? I got to go back a second. I missed that.
Complained about a fair trial in Leon and considering the publicity, Rashomon Drana, were the grounds for a change of venue. I don't think there will ever be a change of venue for any of these
Okay.
Adelsons. There's not enough Tallahassee folks that know about this.
Okay. If Carl says it, I believe it. If I was their lawyer, I'd be fighting for it, though.
Yeah, Lisa Burton, we don't know who the lawyer is yet. I think she's still shopping around. It may take her another month before they find somebody.
She's got to have it before December 12th or December 10th.
Veronica, you're saying they should hurry up and arrest Wendy. I feel like once her boys are 18, there she's going to try to flee. Yeah, I just don't get this. It's so bizarre. Rosemary, you're asking how long is this appeal process and if Charlie Edelson gets a new trial. That's what I'm saying. I'm predicting he's going to get a new trial. I think it could happen really fast, like within 30 days or so. If the state appellate court grants the referral of this case back to the trial court, I think this thing will happen within weeks and not much more than a month, I would say at the longest. Yeah, Fletcher boy, I've been saying that if Donna passed away before trial and Charlie gets a new trial, would Charlie be more inclined to testify against Wendy? For sure. If Wendy dies, Donna dies, and Charlie's facing his new trial, I think that would be a great impetus for him to decide, you know what, I got to go for broke. I'm gonna bring Wendy down with me, and at least I have a potential shot of getting out before I die and seeing my son. Yeah, Rebecca, you're right. Men and women don't mingle in Leon County Jail. So Charlie's not going to get to see Don and vice versa.
That's what I'm thinking.
Yeah, Claudia Gutierrez, you're saying what a train wreck. I pray they do not throw his conviction out. I'm just telling you from a constitutional standpoint, I'm big on the Constitution. It doesn't matter how bad and heinous the crime is. If there's dirty dealings, if there's corrupt dealings, if there's unethical dealings and blatant constitutional violations, really for the betterment of American justice system, we got to make things right. We can't let those things slide and say, well, it's just, he's such a bad criminal. He's such a heinous murderer. We got to let things slide. No, we got to retry it and do it right is the way I feel strongly. And so as much as it's, rehashing everything for the victims, it's so frustrating and outrageous. That's really the big justice and that we have our Constitution to rely upon. It looks like I'm about to sign off here. My battery's about to go down. So yeah, Mandy, they're gonna be able to find jurors. Not too many people have seen this.
Now I feel like a stomping my feet like a child.
Tracy, yeah, I don't know about us writing a book. I'll talk to John about that. Just to wrap it up, today we had a motion filed by the attorney for Charlie Adelson. They're trying to have this case remanded to the trial court level to have the trial court determine if Rashomon was conflicted in Charlie's case, just like with Donna's case, and if that is the case, right, that he was conflicted from the fair and ethical and effective representation of Charlie, then basically Charlie's going to get a new trial. So that's what my prediction is. Charlie's going to get a new trial. Judge Everett's going to be the one to order it. And it may even be stipulated too that there was a conflict by the state attorneys representing this. So in any event, that's all I have for tonight, folks. So thanks for following this. I'll be back on again soon with, I'm going to cover some more of the Sarah Boone case. So not sure. I guess we're going to have some opening statements tomorrow. So I'll probably be back on tomorrow night talking about the opening statements for the parties. So with that being said, more to follow us on this Adelson case. So it gets stranger and stranger, doesn't it? So with that, thanks for supporting the Markells and have a good night.
Why, thank you, Carl. Well, what a day, guys. What a day. Forgot the drinks are free when gambling. Deb says, me too. And I forgot Oh, I missed Deb. Sorry. We'll start saving money for gas, food, and renting. Yep. We still have a year. Yep. They're hoping to have the jury set by noon and sworn in by noon, and so after lunch they could start their opening statements. This is all Willie Meg's fault. Should have just arrested them when they arrested Katie. Oh, God. What a mess, guys. What a mess. Honestly, I'm thinking we should start a petition for the state attorney's office and demanding justice for Dan. I really think we should just show them that people are. Yeah, it's all Wendy's fault. Arrest Wendy now. I agree with you, Sky. This is disgusting. No. Yes and no. It cannot be, the experts cannot speak about it, cannot be brought up unless she brings it up in her testimony. So what that means is she's going to have to testify first before any witnesses, before she can put any witnesses on that are going to talk about battered spouse. So she's going to have to be the first witness for the defense. They're finishing jury tomorrow morning. Judge thinks statement possibly by afternoon. Yeah. I can go along with that suggestion, Rochelle. Of going down to tally. There is a mini jury with alternates. Yes. 6 jurors, and I believe it was 9 alternates. With Sarah Boone, you never know what's next. She's asking for sweets. She may pass out during trial. Jane Kirschman and what WTF is taking so long. Delphi got 12 in like 1.5 days. The defense put in new motions. Oh, they only need a 6 jury of 6 plus alternates. Yeah. And I believe I was told 6 jurors and they were doing 9 alternates. That's a lot of alternates, more than what it's sitting on. So it's insane. Like today has been a crazy, insane day for true crime, that's for sure. Sorry guys, when I itch my nose, and just the medication's giving me an itchy nose. I do not know why. We should set up a Discord folder, hashtag Florida road trip, where we can coordinate communication, accommodations, get a head count, a budget, and what we need to look for a good idea. Do you want me to set that up on Crime and Coffee, Shrez? I know, but they did selection Monday and Tuesday and only need 6 and then 8 alternates. Our justice system's irritating you right now. Yep. 6 jurors will convict her before lunch. It's just Crime and Coffee, but I can't seem to do it. I don't know how to I don't know how to get the link. And God forbid they set court dates in hurricane season. Oh my God. Judge is really angry with the circus with Boone. The trial should be a go. Unless something happens. Okay, perfect. I will set that up. So I'll do it right now. Let me just add a... Add. Oh, wait, no. Maybe I have to do it on, maybe it won't let me do it there. Hold on. Let's see if I can do it here. Where is this? Why won't this open up? There we go. We go here. Oh, there it is. Yeah, okay. Add a channel. What do we call it? Florida road trip. There we go. Create a channel. There we go. It is there, guys. Remember, one juror had for COVID, can be contagious before symptoms, could have infected others who could get sick later, will need alternates. Yep. Free B&B at my co-op garden unit in DC for all crime and coffee crew. Jane, you're amazing. I was just about to go try and figure that out. The link from description box is also bad. Oh, I'll have to figure that out. Can we put up some other picture like I need to get my head on Boone Adelson is done? Okay, let me find something here. Let me just go. We'll just put that up for a second. Okay, thank you, Shiraz. Does this... Oh, somebody just beeped in. I just heard it. Oh, there we go. You're in now. Oh, they expire after a few days. Okay. So much more fun than watching alone. Yep, I agree. So I have to put a new Discord link in all the time. Oh, that's annoying. Okay, guys, I am going to have to call it a night. Oh, Discord's going. There we go. But, we can still chat on Discord. It's just time for me to lay down. But thank you all so much for joining me. Thank you, mods. I greatly appreciate you. This has been quite the day. I will be watching the Discord, can you hear it? Ba-doop, ba-doop, ba-doop. I will be watching the docket for that to drop hopefully tomorrow. And if it drops, you'll be the first to know. And let's get this road trip together. Coffee crew taking over 3B or 3G. Thanks, Deb. I will. Okay, everyone. Good night. Thank you. I appreciate every single one of you. Have a wonderful night. We'll be talking to you soon.